Assalamualaikum warahmatullahi wabarakatuh. Good morning. Welcome all the respected participants and guests of the Second International Conference of Law, Governance, and Social Science, Faculty of Law Jenderal Sudirman University, Indonesia. We are delighted to have you all. Assalamualaikum warahmatullahi wabarakatuh. Assalamualaikum warahmatullahi wabarakatuh.
Waalaikumsalam.
Waalaikumsalam.
Selamat pagi.
Good morning. Welcome all the respected participants and guests of the Second International Conference of Law, Governance, and Social Science, Faculty of Law Jenderal Sudirman University, Indonesia. We are delighted to have you all. This is the registration area. Here we would like to make sure all of you are ready to join the event. You can rename your Zoom account with the following format. You can write your room. For example, you are in the room 1 on room 2. You can write your room in the first and then strip. And after that, you can write your position, whether as participants or presenting. And then strip. And then you can write your name. If you are yet to decide which room you are going to enter, you can just name your account with your surname, participant, and also your institution. In the parallel session, we will break out the room according to the name format used while entering the Zoom platform. We encourage participants to use our virtual background that can be downloaded in our website or in WhatsApp group that we posted earlier yesterday. The rules for the conference are, first, please log in with the format name as we announced earlier. 2, the participants are encouraged to activate the camera on your device so we could recognize and be more attractive. 3, it is mandatory for all participants to mute your audio during the opening ceremony and the session. The audio can be activated during the Q&A session on the plenary and the parallel session if the participant want to ask questions. 4, participants should respect the speaker's time and not allow to make any noise and distraction during the speaker presentation. 5, we wish to have interactive and constructive discussion through the conference, so all the participants could engage actively by asking questions in the chat book or asking directly to the speaker on the Q&A session. 6, the certificate for the presenter will be given right after the presentation. And for those who are not presenting papers, we will send the certificate to your registered email after the conference. 7, we are recorded the conference and save the presentation, so everything will be available later on. These are the rules for the presentation during this conference. Now all the participants are welcome, and please make yourself comfortable. Thank you. like to greet the invited speaker. They have already joined us with us today. Professor Nazura from Malaysia. Good morning, Professor. Good morning, Prof. Nazura. Assalamualaikum warahmatullahi wabarakatuh, Prof.
Assalamualaikum.
Good morning.
How are you?
How are you today, Prof?
Yeah, very good.
Thank you very much. We are very pleased to have you today.
Thank you.
We're still waiting for the opening ceremony, so maybe you have something to say to our participant. Uh, we have already we have around 115 participants today, so maybe you have something to greet to the participants. You can please greet the participants.
Yeah. Okay, thank you very much, Madam Chairperson. I'm Nazura from Faculty of Law. I'm the Dean of the Faculty of Law, UKM, University Bangsa Malaysia. And Universitas General Sudirman is not something that is unfamiliar to us. We've been contacting each other for I think past few years, and we have MOU between these two universities. I am very grateful to be here today, to be with you to contributes to your to the conference, and hope to gain something and to share something today, inshallah. Thank you very much, and hope we enjoy the conference throughout the day today. See you around. Bye. Another thing, Madam Chairperson, may I know when the presenter present the papers, who is going to control for the slides?
Prof. Nazura?
Yeah.
Yeah.
I know.
Yeah.
Yeah, please.
Yeah, we actually can give the authorization to the speaker to
control
screen sharing their presentation by themselves.
All right. Okay. Yeah. It's better.
Or if you wish us, so do you wish you screen sharing yourself, or we have?
I will. I want to. Yeah,
okay.
Please. Yeah, please. I will do the screen sharing. I would like to do the screen sharing back. Thank you.
Okay, Prof. We will give the authorization to you to present. Yeah. Okay, thank you very much, Prof. Nazura from Malaysia.
Okay.
Thank you very much. Also we have Dr. Jaja Ahmad Jayus SHM, the Chairman of the Judicial Commission Republic of Indonesia, joining with us today. Good morning. Good morning, Pak Jaja. For all the participants, you can please formatting your name regarding the format that we have announced earlier. Please write your room and also your name, and then your position, whether as participant or presenter. After the plenary session, we will break out the room and we will place you as the position. Good morning. Welcome all the respected participants. Once again, I would like to remind all of you, maybe for the participants that just joined in this room, we are delighted to have you all. This is the registration area. Here we would like to make sure all of you are ready to join the event. You can rename your Zoom account with the following format. First, read your room, the room that you are willing to join. For example, you will join in the room 1 for the presentation. You have to write your room first, and then strip, and then write your position, whether you are as participant or presenter, and then write your name right after. If you are yet to decide which room you are going to enter, you can just name your account with your surname and participant and your institution. In the parallel session, we will break out the room according to the name format used while you entering the Zoom platform. We encourage our participants to use our virtual background that can be downloaded in our website earlier yesterday. The rules for the conference are: 1. Please log in with format name as we announced earlier. 2. The participants are encouraged to activate the camera on your website, on your device, so we could recognize and be more interactive. 3. It is mandatory ceremony and the session. The audio then can be activated during the Q&A session on the plenary and parallel session if the participant want to ask questions. 4. Participants should respect the speaker time and are not allowed to make any noise and distraction during the speaker presentation. 5. We wish to have interactive and constructive discussion through this conference, so all the participants could engage actively by asking questions on the chat book or asking directly to the speakers on the Q&A session. 6. The certificate for the presenter will be given right after the presentation, and for those who are not presenting papers, we will send the certificate to your registered email after the conference. We are record the conference and save the presentation, so everything will be available later on. These are the rules for the presentation during this conference. Now all the participants are welcome, and please make yourself comfortable. We're still waiting for the opening ceremony of this conference. Thank you. For all the participants, if you have question, you can ask by activate your audio to the committee, and we will reply and respond your question. Thank you. Good morning. I would like to greet Dr. Jaja Ahmad Jayus SHMPU, Chairman of the Judicial Commission Republik Indonesia.
Morning.
Good morning.
Assalamualaikum.
Selamat pagi, Pak Jaji.
Pagi.
Waalaikumsalam warahmatullahi wabarakatuh.
Waalaikumsalam warahmatullahi wabarakatuh. Jam berapa kita mulai? Jam
Before, yes, kita berencana memulai jam 9.
Okay.
Masih menunggu opening ceremony. Terima kasih sudah bergabung bersama kami pagi ini, Pak.
Ya.
Terima kasih. We would like also greet our invited speaker, Prof. Thomas Smith from Groningen, German. Are you ready to join with us today? Hello, Prof. Thomas Smith? Not yet? Okay. Maybe Prof. Osaid Awauda from Palestine. Have you joined us? Not yet? Okay, we're still waiting for the opening ceremony. Good morning for all the participants. Thank you for joining us today. This is the first day of the conference. We will have the plenary session, 2 plenary sessions today, in the morning and also in the afternoon after the break virtual tour in Purwokerto. For the second day, we have the last parallel session. So this conference will be conducted in 2 days. Hopefully all of you will join completely from the first to the second day, and the certificate will be given right after the conference ends. If you have any question, you can ask the committee by raise hand and activate your audio. We will respond immediately. Thank you.
Raise hand. Raise hand nggak ada. how to write attendance, please? Attendance daftar hadir.
Oh, the attendance we will post in the chat room.
Okay, thank you.
Halo.
Halo Prof.
Iya.
Thomas. Have you join us?
Aduh, sebentar. Iki aku masih tersambung Zoom sebentar ya. Aku sampai sarapan dikit, Mas Budi. Iya, sebentar. Aduh.
Good morning, Prof. Thomas. Have you joined us? Good morning. Thank you for joining us today. Okay. Ladies and gentlemen, and all the respected participants, now the opening ceremony will shortly begin. So I would like to welcome for all the participants and also the invited speaker. After this, you will be directed to the main hall. Thank you.
Materai ditandatangani kalapas. Yo, wis. Itu terserah harus iki apa itu terserah materai itu. Iya, gua enggak apa.
Tes.
Check.
Tes.
Ya.
Check.
Tes. Tes.
Check. live stream from Faculty of Law Jenderal Sudirman University and Banyumas TV YouTube channel. Ladies and gentlemen, welcome to the second International Conference on Law, Governance and Social Justice. In a few minutes, the main agenda will be begun. To all of the participants, please turn on your camera and pay attention. Ladies and gentlemen, now please welcome our Master of Ceremony, Mrs. Sri Wahyu Handayani SHMH and Mr. Muhammad Irfan Ramadhani.
Assalamualaikum warahmatullahi wabarakatuh.
Good morning, ladies and gentlemen. May peace be upon all of us. First of all, let's thank to the Almighty God for His guidance and mercy, so we can attend the second International Conference on Law, Governance and Social Justice today in Faculty of Law, Universitas Jenderal Sudirman, Purwokerto, Central Java. This conference is organized by Universitas Jenderal Sudirman. And before starting the first session, let us introduce ourselves. I am Sri Wahyu Handayani.
And I'm Muhammad Irfan Ramadhani.
We'll guide you as the Master of Ceremony.
Without any further ado, I would like to welcome our speakers today. The Honorable, the Assistant of Regent of Banyumas Regency. The Honorable, Professor Dr. Kuat Puji Prayitno SHM Hum as Vice Rector of Academic of Universitas Jenderal Sudirman.
The Honorable Professor Dr. Ade Maman Suherman SHMSE as Dean of Faculty of Law, Universitas Jenderal Sudirman.
The Honorable Keynote Speaker, Dr. Jaja Ahmad Jayus SHM Hum as Chairman of the Judicial Commission Republic of Indonesia.
The Honorable Dr. Teddy Sudrajat SHMH as Chief Executive of the second ICOLGAS 2020.
The Honorable, all of the speakers. First, Professor Dr. Thomas Smith, DA.AD, Lecturer at Universitas Gajah Mada and Adjunct Professor at the University of Göttingen, Germany.
Second, Professor Dr. Naura Abdul Manap from University Kebangsaan Malaysia.
Third, Professor Dr. Ade Maman Suherman, SHMSc from Universitas Jenderal Sudirman.
Fourth, Assistant Professor Osed Awawda, LLB, LLM, PhD from Hebron University, Palestine.
Fifth, Professor Dr. Igusti Ayu Ketut Rahmi Handayani, SHMM from Universitas 11 Maret.
Sixth, Professor Tri Lisiani Prihatina, SHMA, PhD from Universitas Jenderal Sudirman.
The Honorable, all VIP guests, all presenters, participants, and
all committees and attendees.
Ladies and gentlemen, starting the first session, let us deliver the structure of today's program. First, singing the Indonesian national anthem, Indonesia Raya. Second, recitation of prayer. Third, welcoming dance. Fourth, opening ceremony and welcoming remarks. Fifth, keynote speaker. Sixth, there will be break and we'll play video profile Faculty of Law Universitas Jenderal Sudirman. 7. Plenary session 1. 8. We'll play virtual tour of Purwokerto. 9. Plenary session 2. And 10. We'll play virtual tour of Purwokerto. And last, parallel session 1.
And day 2, first, parallel session 1. Second, publication information from ICOLGAS committee. And third, closing ceremony. And now, let's start the first session by singing the Indonesian national anthem, Indonesia Raya. Ladies and gentlemen, please stand up. Ladies and gentlemen, please be seated.
The second session, we would like to invite Dr. Andes Nur Asik Aim AG to lead the prayer. To Dr. Andes Nur Asik Aim AG, time is yours.
Assalamualaikum warahmatullahi wabarakatuh. Hadirin peserta International Conference, marilah sejenak kita menghadirkan hati kita ke hadirat Tuhan Yang Maha Esa Allah. Muhammadin wa ala alihi wa ashabi ajma'in. Alhamdulillahi rabbil alamin. Hamdan na'imin. Hamda yuafi ni'amahu wa yukafi mazidah. Ya Rabbana lakal hamdu kama yanbaghi li jalali wajhika wa adimi sultanik. Ya Allah, ya Azza wa Jalla, dengan rasa syukur dan kesucian hati kami sebut namamu yang agung, karena hanya berkat rahmat dan hidayahmu sehingga kami dapat menyelenggarakan Second International Conference on Law, Governance and Social Justice 3-4 November 2020 dalam rangka Disnatalis ke-39 Fakultas Hukum Universitas Jenderal Sudirman. Maka berilah kelancaran dan kesuksesan dari awal hingga akhir. Ya Allah, ya Malikal Mulk, ya Alim, kami sebagai bagian dari intelektual dan akademisi berkumpul di sini secara virtual memiliki tanggung jawab untuk memberikan pemikiran terhadap pengembangan keilmuan. Maka bimbinglah kami dengan hidayah dan ilmumu agar dapat memberi manfaat bagi masyarakat, bangsa dan negara serta dunia. Ya Allah, ya Rahman, ya Rahim, pada masa pandemi COVID-19 ini kami semua di seluruh dunia mendapatkan ujianmu. Kami terima dengan ikhlas dan sabar, karena pasti ada hikmah di balik ujianmu. Maka segera lenyapkanlah ujianmu. Jangan engkau timpakan ujian yang kami tidak sanggup memikulnya. Maka curahkanlah kasih dan sayangmu, agar kami mampu menebarkan kasih sayangmu, menjadikan tata kehidupan dunia yang baldatun, toyibatun, warobun ghafur, kemahripah lojinawi, toto tentrem kertorahajo. Ya Allah, ya Ghaffar, ya Hadi, ampunilah segala dosa kami, pemimpin kami, sucikan jiwa dan hati kami. Berikanlah hidayahmu agar kami dapat memberikan yang terbaik bagi masyarakat, negara, bangsa dan dunia. Di bawah ridhamu, berilah kami rahmatmu, rizki yang penuh berkah dan kehidupan tentram, damai, sejahtera. Ya Allah, ya taqabbal doa, terimalah doa kami yang tulus. Allahumma aghnina bil ilmi wa zazina bil hilmi wa akrimna bit taqwa wa jamilna bil afiyah. Rabbana atina fid dunya hasanah wa fil akhirati hasanah wa qina adzabannar. Subhana rabbika rabbil izzati amma yasifun wa salamun alal mursalin walhamdulillahi rabbil alamin. Wassalamualaikum warahmatullahi wabarakatuh.
Ladies and gentlemen, now we are coming to the third session. It's welcoming the traditional dance called Tari Ngero.
Ngerong dance is a new creative dance accompanied by calung Banyumasan. Ngerong dance is taken from the word renggong, which is known as the term lengger, and gets the suffix nge, which means to do. So, ngerong is to do lengger or to dance lengger. Ladies and gentlemen, please give applause to Tari Ngerong.
Thank you very much for turning it on. Ladies and gentlemen, and now we will hear some speech in the next session.
The first speech will be delivered by our Chief Committee. To Dr. Teddy Sudrajat, SH.MH, time is yours.
Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh. Peace be to the peace and God blessing be to you all. Good morning and hope everyone in good health right now. Our Honorable Rector, which represented by Third Vice Rector, Dr. Kuat Puji Prayitno, SIM Home. Our Honorable Dean Faculty of Law, Universitas Jenderal Sudirman, Professor Dr. Ade Maman Suherman, SHMSG, our Honorable invited speakers and keynote speakers, Chairman of Judicial Commission Republic of Indonesia, Dr. Jaja Ahmad Jayus, SIM Home, our Honorable invited speaker, Professor Thomas Smith, Professor Nazura Abdul Manap, Assistant Professor Osaid Awauda, Profesor Dr. Igusti Ayu Ketut Rahmi Handayani, Profesor Dr. Ade Maman Suherman, and Professor Trilisiani Prihatina. Our distinguished guests, Assistant of Regent, Banyumas Regency, from District Court, from District Attorney and University around Purwokerto, all of the participants, and also the presenters and committee also. First of all, we thanks to Allah of giving us the opportunity to be gathered in this international conference. We will have a fruitful discussion relating with the international conference, law, governance, and social justice. After successfully hosting the first international conference on law, governance, and social justice in 2018, in 2020, right now, we held the second international conference on law governance, and social justice as a main part of faculty anniversary that we call as Dis Natalis in 39th for Faculty of Law, Universitas Jenderal Sudirman. This international conference is an effort of the Faculty of Law UNSUD to show global existence in contributing critical thoughts and studies to the scientific development of law, governance, and social justice. For that reasons, we invite 7 speakers right now. The first is Chairman of Judicial Commission of the Republic of Indonesia, Dr. Jaja Ahmad Jayus, SIM Home. As a keynote speaker, will deliver his speech on the Judicial Commission in legal order and access to justice. And the second of one, Professor Thomas Smith, DAD lecturer at Universitas Gajah Mada, and adjunct professor at the University of Göttingen, Germany, who presented the issue of the pandemic and legal comparison regarding the COVID-19 response and human rights, comments from the German and European perspective. Professor Nazura Abdul Manap, the Dean Faculty Undang-Undang University Kebangsaan Malaysia, who presented legal issue regarding the copyright tribunal in Malaysia. The fourth is Professor Dr. Ade Maman Suherman, SHMSC from Universitas Jenderal Sudirman, who presented the global governance and social justice at the World Trade System Indonesian perspective. And Assistant Professor Osaid Awauda, LLB, LLM, PhD, Hebron University, Palestine, convey an international issue regarding the regime violations of right to property in the West Bank, Palestine, Professor Dr. Igusti Ayu Ketut Rahmi Handayani, SIMM, from Universitas 11 Maret, who presented governance issue, Professor Trilisiani Prihatina, SIMA PhD, Universitas Jenderal Sudirman, who presented legal issue regarding sustainability and its responsibility. This international conference, ladies and gentlemen, will head for 2 days, 3rd and 4th November 2020, in a blended way, offline and online. Conduct offline at Judicia 3rd Hall at Faculty of Law, Universitas Jenderal Sudirman. And online, we presented by Zoom application and YouTube Live that we have a collaborations between Banyumas TV and LPTC Universitas Jenderal Sudirman. This conference will attend by 457 participants. There are 176 selected articles that will be presented on 9 topics related with the law, governance, and social justice, such as international law, social justice and human rights, constitutional law, administrative law, criminal law and criminal justice system, specific issue related with the pandemic, business and commercial law, law and public policy and legal protections. And the output of this article will be published in the international journal, national journal, and also in proceedings. In these occasions, as a chairman, I would like to thank to the entire committee who have devoted their time, energy, and thought so this conference can run successfully. And also we would like to say thank you very much for all speakers, keynote speakers, and invited speakers, presenters, and participants for their attendance and participation also. I believe that we will have a fruitful discussions. We will get a clear and balanced understanding in analyzing law, governance, and social justice issue that can create a solution for us. Have nice discussions, and we hope all of you can enjoy this conference. Thank you very much. Assalamualaikum warahmatullahi wabarakatuh.
Thank you, Dr. Teddy Sudrajat, for your opening speech.
And ladies and gentlemen, now the second speech will be delivered by Dean of Faculty of Law, Universitas Jenderal Sudirman, to Professor Ade Maman Soherman, SH, MSc. Time is yours.
Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh. Best wishes for all us and peace be upon to all of us. The Excellencies, Rector of Universitas Jenderal Sudirman, the Excellencies, keynote speaker, and honorable all invited speakers, and the honorable guests, distinguished delegates, participants, colleagues, ladies and gentlemen, a very good morning. It is indeed a great honor and a pleasure to welcome you all to the second ICOLGAS here in Purwokerto, Central Java, in Indonesia. Ladies and gentlemen, first of all, I would like to extend our sincere thanks, especially to all the audience who attend the meeting here directly and physically, and also to all the participants who attend this conference by virtual meeting. And then I would like to thanks to all the invited speaker, Dr. Jaja Ahmad Jayus, SHM, the chairperson of Judicial Commission of the Republic of Indonesia, as the keynote speaker. He delivered his speech on the Judicial Commission in Legal Order and Access to Justice. The second, Professor Dr. Thomas Smith from the AD lecturer at Gajah Mada University and adjunct professor at University of Göttingen, Germany, who presents the issue on the pandemic and legal comparison regarding the COVID-19 response and human rights comment from the German and European perspective. And the third speaker, Professor Dr. Nazura Abdul Manap from University Kebangsaan Malaysia, and also she is a Dean Faculty of Law, University of Kebangsaan Malaysia. She presents legal issue regarding the copyright tribunal in Malaysia. And the fourth, Professor Dr. Adimaman Suherman, SIMSG, I myself from General Sudan University. I will talk about global governance and justice of the World Trade System from Indonesian perspective. And the next speaker, Assistant Professor Osaj Awauda, LLB, LLM, PhD, from Hebron University, Palestine. He delivers an international issue regarding the regime violation of the right to property in the West Bank, Palestine. And then also the next speaker, Professor Dr. Igusti Ayu Ketutrahmi Handayani, SHMH, from 11 Maret University. And also now she is acting as the Dean Faculty of Law, University of 11 Maret. She talks about good governance. And then also my colleague, Professor Tri Lisiani Prihatina SMA PhD from Faculty of Law, Jenderal Sudirman University. She talks about international civil law regarding sustainability and its responsibility. Ladies and gentlemen, interestingly, to discuss in global issues such as law, governance, and social justice. Always important to discuss and these aspects in terms of to achieve the country's goal. But on the other hand, the dynamics of global political environment and the outbreaks of pandemic have pushed all the countries to walk without clear direction and unpredictable policy. Pandemics in general are not merely serious public health concern, rather these trigger disastrous socio-economic and also political crises in the infected countries. COVID-19, apart from becoming the greatest threat to global public health of the country, is being considered as an indicator of inequity and deficiency of social advancement. The honorable invited speakers, distinguished guests, ladies and gentlemen, discussing legal issues, governance, and social justice is not an easy task, especially in the condition of the COVID-19 pandemic. It takes a lot of radical adjustment and change. At least there are two big issues, such as, first, state policies and change legislation. Legislation change and measures adopted due to the COVID-19 pandemic, a new law amending various legislative acts, including laws on emergency prevention and control, and the tax code was adopted in many countries. The following amendments were introduced, such as rent introduction and deferment of payment under real estate lease, bankruptcy regulation and postponement, special procedure for collecting interest, penalties and fines for late payment and utilities, and also restriction on business infection, suspension of measures for recovery of tax payment, postponement of deadlines for submission of reporting, reduced social insurance contribution rate for small and medium businesses, deferment of payment of taxes and social insurance contribution for companies from certain industries, and also debt restructuring during the lockdown period, and non-fulfillment of obligation due to COVID-19 pandemic. Ladies and gentlemen, the second, it's always happened in many countries, freedom versus strict restriction from the state. It's big problem. In the context of governance, the government is expected to be able to regulate and to manage community needs according to the problems that occur, to be adaptive and give a solution to the current condition. The sharp debate between the community and the government about freedom versus social restriction or quarantine, lockdown, is a common phenomenon throughout the country in facing global pandemic. A new challenge that is not easy, but I do believe that through legal and governance approaches and social justice, the state and international society is able to reconstruct the world order in a framework of just global governance through national and international legal instruments. Through a social justice approach, law and governance should intertwine to provide fair treatment so as to form a just and prosperous social life. The honorable invited speaker, distinguished guests, ladies and gentlemen, I am, as the Dean Faculty of Law, grateful to the many experts who have come to share their knowledge in this week for today to come. I also welcome the many representatives from many various universities, government, institutions, lawyer associations, and others who have joined in this conference. I'm sure you will have fruitful and rewarding exchange and experience in the next 2 days. I wish you every success with this important conference, and I look forward to learning about the outcome. I wish you, in the name of Faculty of Law, a successful and enlightening conference. Thank you very much. Wassalamualaikum warahmatullahi wabarakatuh.
Thank you for the speech, Dean of Faculty of Law.
The third speech will be delivered by the Vice Rector of Academic of Universitas Jenderal Sudirman, followed by symbolic opening of this event accompanied by Dean of Faculty of Law and Chief Committee of ICOLGAS. To Dr. Kuat Puji Praetno, SHM Hum, time is yours.
Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh. Alhamdulillah wa syukurillah. Wala khawla wala quwata illa billah. Asyhadu an la ilaha illallah wa asyhadu anna Muhammadan abduhu wa rasuluh la nabiyya ba'dah. The Honorable Dean of Faculty of Law, University of Jenderal Sudirman, Profesor Ari Maman, Vice Dean, Dr. Setiawahyudi, Dr. Nur Indriati, and Dr. Kartono, lecturers, staff, and students. The Honorable keynote speaker, Dr. Jaja Ahmad Jayus, invite speakers from India, Malaysia, Germany, Palestine, Gajah Mada University, and UNS. Nice to meet you. Honorable presenters and distinguished guests, ladies and gentlemen. Good morning and best wishes for all of us. On behalf of University of Jenderal Sudirman, I am Vice Rector, would like to welcome. It is my great pleasure to have an opening speech at the second International Conference of Law on Law Governance and Social Justice 2020. In this very nice time, firstly, I would like to say thank you and welcome to everyone who attend the second of International Conference of Law, Governance and Social Justice, organized by the Faculty of Law, University of Jenderal Sudirman. Faculty of Law of University Jenderal Sudirman, one of the best faculty in university. Ladies and gentlemen, the law, governance, and social justice are three concepts that cannot be separated. In this case, the university have contribution to analyze, to evaluate, to create these concepts, to realize the social justice for all Indonesian people. Pancasila Part 5. Ladies and gentlemen, this conference provides a forum of scholars, researchers, and practitioners to share their ideas, result of the research, and experience in dealing with the recent issues on the challenges of law, society, and governance. Therefore, we really appreciate the program conducted by the Faculty of Law, and I do hope this conference produce output, particularly in the field of law enforcement. And also, this forum is very strategic to develop both the language skill as well as the concept of legal thinking internationally. Ladies and gentlemen, once again, congratulations to the committee and all participants. May Allah subhanahu wa ta'ala will always blessing us. Amin, amin, ya rabbal alamin. And finally, with the name of Allah subhanahu wa ta'ala, Bismillahirrahmanirrahim, the second International Conference on Law, Governance and Social Justice 2020 officially open. Thank you. Assalamualaikum warahmatullahi wabarakatuh.
Sorry for Dr. Kuat Puji Praetno. Maybe we can open this event with hitting the gong with the Chief Committee of ICOLGAS, Dr. Teddy Surjat. Please accompany.
Ada pintu ya. Terus introduction-nya belum buat, sana formatnya gimana, ekonomi belum ngerti.
And now we will invite the Vice Rector, Dean, and all of the VIP guests to take photo session. Please come to the stage for all the VIP guests. thank you for all the VIP guests, Vice Rector, and Dean. Please be seated. Thanks for the Chief of Court. Thanks for the Chief of Pengadilan Negeri, Pengadilan Agama, dan Kejaksaan in Purwakarta who has come in this moment. And ladies and gentlemen, now we come to the keynote speech will be delivered by Chairman of the Judicial Commission Republic of Indonesia. But before that, we will read his curriculum vitae.
Dr. Jaja Ahmad Jayus SHM was born in Kuningan, April 6, 1965. He has finished his educational background as Bachelor of Law, Faculty of Law, Universitas Pasundan at 1989. Master of Law, Universitas Parahyangan on 2001, and Doctor of Law, Universitas Pajajaran on 2007. He also has a lot of work experience as member of Judicial Commission Republic of Indonesia from 2010 until 2015, and chairman of Judicial Commission Republic of Indonesia from 2018 until 2020. He also launched the books at Customary Law, Disputes, Conflict and Community Protection on 2020.
And now, please welcome Dr. Jaja Ahmad Jayus HHM.
Assalamualaikum warahmatullahi wabarakatuh. Yang saya hormati Rektor Universitas Jenderal Sudirman, yang dalam hal ini diwakili oleh Dr. Fuad sebagai pembantu Rektor 3, wakil Rektor 3, dan saya di Bandung PT. Kemudian Dekan Fakultas Hukum Universitas Diponegoro, Pak Profesor Ade Maman, satu kampung dari Kuningan, cuma beda kecamatan. Para narasumber yang saya catat di sini ada yang dari India, kemudian dari Jerman, Malaysia, dari IGM dan dari UNSUR. Para partisipasi konferensi ICOLGAS yang kedua, hadirin yang berbahagia. Perkenankan saya menggunakan bahasa Indonesia karena berdasarkan undang-undang bahasa, saya kalau berbicara sebagai ketua PAI harus menggunakan bahasa Indonesia. Pertama-tama kita memanjatkan puji syukur kepada Allah Subhanahu wa Ta'ala karena pada hari ini melalui Zoom, melalui virtual, kita melaksanakan konferensi yang diselenggarakan oleh Fakultas Hukum Universitas Jenderal Sudirman dari tanggal 3 sampai dengan tanggal 4 besok hari Rabu tahun 2000, November tahun 2020. Tadi Dekan Fakultas Hukum Universitas Pasundan, Universitas Diponegoro telah menjelaskan bagaimana perkembangan tatanan ilmu hukum, kemudian pemerintahan dan social justice, utama di era pandemi. Beberapa tahun belakang, katakan sejak tahun 2017, 2018, 2019, para cendekiawan, para ahli, baik di bidang hukum maupun di bidang lainnya, sering membicarakan tentang revolusi industri 4.0 dan 5.0. Namun, diskusi itu seringkali hanya sebatas pada wacana, tindakan yang signifikan, lebih konkret untuk merubah tatanan kehidupan berbangsa dan bernegara masih dalam tataran kurang implementasinya. Nah, oleh karena itu dalam suasana pandemi sekarang ini terasa bahwa revolusi industri 4.0 dan 5.0 merubah tatanan kehidupan bermasyarakat di belahan dunia, termasuk di Indonesia, lebih-lebih dengan suasana pandemi sekarang ini. Dalam suasana pandemi sekarang ini, maka cara bertransaksi itu sudah menggunakan media teknologi. Tidak lagi kontan, sebagaimana dikenal dalam kehidupan sehari-hari pada masyarakat Indonesia. Termasuk sekarang, kalau kita menyelenggarakan konferensi atau seminar atau diskusi-diskusi yang biasanya secara fisik berhadap-hadapan, sekarang banyak dilakukan secara virtual. Bahkan bulan yang lalu, bulan Oktober, Mahkamah Agung diskusi dengan Mahkamah Agung Singapura, Mahkamah Agungnya Australia, juga melalui virtual, kemudian melakukan studi banding tentang pelaksanaan proses persidangan secara virtual di masing-masing negara, baik di Indonesia maupun di Australia dan di Singapura. Dengan beragam kendala, beberapa persidangan itu dilakukan secara virtual. Nah, tentunya ketika Mahkamah Agung mengeluarkan kebijakan dengan mengeluarkan litigasi atau persidangan melalui teknologi informatika, maka beberapa proses dalam suasana pandemi ini sudah dilaksanakan, terutama dalam perkara-perkara pidana. Bahkan dalam perkara perdata, kalau menjawab atau gugatan menjawab replik-replik itu juga sudah dilakukan secara menggunakan teknologi informasi itu. Nah, ini tentunya akan merubah tatanan dalam implementasi penegakan hukum di Indonesia. Dalam konteks Komisi Yudisial, perubahan-perubahan yang terjadi tersebut dalam konsep negara hukum, sebagaimana kita ketahui, konstitusi kita, Undang-Undang Negara Republik Indonesia tahun 1945, dalam pasal 1 ayat 3-nya telah menegaskan bahwa negara kita adalah negara hukum. Konsep negara hukum yang berlaku sejak Undang-Undang Dasar ditetapkan tahun 1945, kita mengenal konsep pemisahan kekuasaan. Kemudian sekarang dengan suasana reformasi, maka konsep pemisahan kekuasaan negara itu diiringi dengan konsep balances. Kalau kita lihat perkembangan konsep check and balances itu dimulai dari dunia politik, kemudian diadopsi dalam ilmu hukum, kemudian itu menjadi bagian daripada yang diperjuangkan dalam suasana reformasi sejak tahun 98. Jadi kalau kita berangkat perjalanan tatanan negara hukum setelah kita menetapkan Undang-Undang Dasar 1945 tahun 1998, kita ada reformasi di bidang hukum, antara lain kita melakukan amandemen terhadap Undang-Undang Dasar, kemudian dalam Undang-Undang Dasar 45 hasil amandemen itu lembaga-lembaga negara baru, antara lain adalah Komisi Yudisial. Nah, kenapa Komisi Yudisial itu dilahirkan, antara lain tujuannya adalah bagaimana mewujudkan masyarakat adil dan makmur sebagaimana dimaksud dalam Undang-Undang Dasar 45. Jadi kalau kita berbicara konsep komisi yudisial di dalam tataran negara hukum, maka pertama, sebagaimana dinyatakan di dalam pasal 24B ayat 1 Undang-Undang Dasar 1945 yang menyatakan bahwa komisi yudisial merupakan lembaga yang mandiri, di mana memiliki wewenang untuk mengusulkan pengangkatan hakim agung pada DPR, tambah sekarang dengan undang-undang tentang komisi yudisial punya kewenangan untuk juga mengusulkan pengangkatan hakim ad hoc pada Mahkamah Agung. Jadi di kita itu ada hakim agung, ada hakim ad hoc pada Mahkamah Agung, yaitu Tipikor dan PHI yang sekarang eksis, yang sekarang juga digugat di Mahkamah Konstitusi oleh beberapa staf pengajar dan pengacara bahwa kewenangan komisi yudisial tidak memiliki kewenangan untuk mengusulkan pengangkatan hakim ad hoc pada Mahkamah Agung. Itu bisa debatable, silakan para ahli hukum itu bisa membahasnya apakah hakim ad hoc pada Mahkamah Agung itu bukan hakim agung, nah fungsinya dia itu menjalankan fungsi-fungsi sebagai hakim agung, fungsi-fungsi sebagai suatu hakim yang memutus di tingkat tidak juris, bukan lagi di tingkat faksi. Di mana tingkat tidak juris, kasasi dan kembali merupakan tugas sebagai seorang hakim agung. Yang undang-undang itu dua hakim agung dan hakim ad hoc. Kemudian di dalam undang-undang, di mana KAI memiliki kewenangan lain dalam rangka menjaga dan menegakkan kehormatan atau martabat hakim, dalam undang-undang diterjemahkan itu menjadi tugas melakukan pengawasan atau fungsi pengawas eksternal. Nah, sebagai pengawas eksternal, komisi yudisial diharapkan senantiasa mampu mengembalikan hitah atau marwah hakim di lingkungan badan-badan peradilan dan Mahkamah Agung atau Mahkamah Agung dan badan-badan peradilan yang ada di bawah. Nah, di sini sebagai pengawas eksternal, maka itu implementasi daripada konsep independensis, di mana komisi yudisial walaupun bukan pelaksana kekuasaan kehakiman, namun fungsinya berkaitan dengan kekuasaan kehakiman. Nah, karena itu di dalam Undang-Undang Dasar 1945 posisinya ada di bab tentang kekuasaan kehakiman. Nah, dalam kerangka menjalankan fungsi pengawasan, maka sebetulnya komisi yudisial itu menjembatani para pencari keadilan untuk mewujudkan bagaimana agar akses terhadap keadilan itu bisa dilaksanakan secara maksimal. Kenapa demikian? Karena kita tahu walaupun sekarang orang banyak bersidang di pengadilan, masih mendengung-dengungkan kadang-kadang putusan itu tidak sesuai dengan perasaan keadilan yang mereka rasakan. Berarti sampai sekarang keadilan itu masih diperjuangkan oleh para pencari keadilan, baik masyarakat langsung maupun kuasa daripada masyarakat yang berperkara di pengadilan. Nah, oleh karena itu keadilan yang kita perjuangkan itu adalah sesuatu yang menjadi perhatian bagi masyarakat para pencari keadilan. Karena keberadaan komisi yudisial dalam tatanan kehidupan berbangsa dan bernegara upaya mengawal proses keadilan yang diwujudkan oleh lembaga peradilan agar berjalan transparan, akuntabel, atau berjalan dengan tanpa memihak atau hakim dalam memutus itu betul-betul menerapkan prinsip-prinsip imparsialitas. Nah, agar bisa mewujudkan itu, maka Komisi Judisial sebagaimana tadi dalam Undang-Undang Dasar 45 dan Undang-Undang memiliki tugas dan wewenang, pertama melakukan seleksi hakim agung dan hakim ad hoc pada Mahkamah Agung, diharapkan melalui suatu proses seleksi yang sangat ketat di Komisi Judisial. Bahkan ada cerita dari teman-teman saya yang sering mengikuti proses seleksi lembaga-lembaga negara lain, itu proses seleksi di Komisi Judisial itu tidak memiliki suatu sistem yang susah ditembus, walaupun akan misalnya saya punya kenalan, tapi sangat susah kalau saya bisa memaksakan agar seseorang itu bisa lolos untuk menjadi agung atau hakim ad hoc. Sistemnya begitu ketat, apalagi dengan rekam jejak yang kadang-kadang kita juga diminta bantuan oleh Sekretaris Negara dalam rangka melakukan seleksi di Mahkamah Konstitusi. Nah, kemudian dalam rangka mewujudkan akses to justice, saya ini menerima laporan pengaduan masyarakat. Dalam suasana pandemi sekarang, tadinya dalam bulan yang sama, ya, pada tahun sebelumnya, katakan tahun 2019, diharapkan menurun, ternyata walaupun ada penurunan tetapi tidak signifikan. Kalau berdasarkan data yang ada di Komisi Judisial, misalnya penerimaan laporan masyarakat sejak 2015 sampai dengan 2019 itu berjumlah ada 15.309 laporan. Dalam 45 tahun yang hakim yang dilaporkan ke Komisi Judisial, baik laporan langsung maupun putusan, itu berjumlah 15.309 laporan. Atau yang laporan langsung itu berjumlah 7.952. Itu artinya rata-rata tiap tahunnya itu lebih daripada 1.400-an, karena ini fluktuatif. Misalnya di tahun 2015 ada 1.491 laporan, tahun 2018 ada 1.792, di tahun 2019 turun 1.594. Nah, di tahun 2020 itu hampir mendekati 1.200-an. Jadi walaupun suasana pandemi sekarang, ternyata laporan masyarakat dalam kerangka memperjuangkan tentang keadilan di pengadilan itu masih banyak laporan yang sangat variatif dan yang paling banyak didominasi oleh pelanggaran terhadap berdisiplin tinggi dan profesionalisme. Nah, ini artinya bahwa putusan itu seringkali akuntabilitasnya itu dipersoalkan oleh para pencari keadilan. Lebih-lebih misalnya pelanggaran-pelanggaran terhadap prinsip-prinsip yang lain, misalnya prinsip integritas tinggi, prinsip arif dan bijaksana, dan lain sebagainya. Seperti kode etik yang merupakan penerjemahan daripada Bangalore Principle, kemudian digabung bersama antara Mahkamah Agung. Nah, kemudian berikutnya, dalam suasana pandemi juga banyak masyarakat yang meminta pemantauan pengadilan. 2 minggu yang lalu saya berkunjung ke Pengadilan Purwokerto. Saya mau datang di kesini, tapi kan 2 minggu yang lalu saya sudah berkunjung ke Purwokerto. Kemudian juga berkunjung ke Wonosobo. Wonosobo saya berkunjung di wilayah Jawa Barat, wilayah selatan. Dan itu pulang dari Wonosobo ke Purwokerto, juga datang ke Kaye, banyak yang minta pemantauan tentang kesehatan, baik itu maupun aman. Artinya apa? Artinya masyarakat ingin minta bantuan kepada Komisi Judisial dalam mencari keadilan. Dan bahkan dalam beberapa kasus di wilayah Jawa Tengah, AY dan Badan Pengawas Mahkamah Agung Komisi Judisial dijadikan pihak gugatan. Yang maksudnya setelah ditanya, ini apa kaitannya kok AY digugat, padahal tidak ada dalam pokok gugatan. keterkaitan komisi judisial. Data sidik ingin kaya langsung mengawasi proses persidangan secara langsung, maka pihak itu menjadikan kaya sebagai pihak dalam perkaranya. Ini orang yang aneh-aneh di masyarakat kita, supaya kaya dijadikan pihak. Nah, kemudian kalau ada penerimaan masyarakat, kemudian kalau terbukti atas laporan itu, maka kaya menjatuhkan sanksi. Dari tadi jumlah laporan yang masuk ke KAI tahun total selama 5 tahun 2015 sampai dengan 2019 ada laporan langsung 7.952 dan laporan dengan tebusan berjumlah 15.309 yang dijatuhkan sanksi memang sangat sedikit dari jumlah itu. Itu kurang lebih hanya 10% dari, bahkan kalau dengan tebusan itu kurang daripada persen. Jadi ada 6%. Misalnya di total sanksi ringan sampai dengan sanksi berat itu hanya berjumlah 837. Dari jumlah 837 itu ada yang dilaksanakan oleh Mahkamah Agung, ada yang tidak dilaksanakan oleh Mahkamah Agung dengan dalil atau alasan bahwa laporan tersebut berkaitan dengan teknis judisial atau prinsip. Bapak Ibu sekalian, para narasumber, rektor, dekan, kemudian partisipan konferensi yang saya hormati, dari data tersebut bahwa terhadap perkara di pengadilan yang masih banyak masyarakat pencari keadilan masih belum menerima atas putusan yang dijatuhkan oleh majelis hakim, walaupun saya katakan tadi dari jumlah yang diputus atau setelah dianalisis oleh komisi judisial, jumlah laporan yang sampai terbukti hakim itu dinyatakan melanggar kode etik dan kode etik hakim itu sangat sedikit, dan itu lebih banyak aspek disiplin tinggi dan fokus medis. Namun demikian, dengan banyaknya laporan ke komisi judisial menunjukkan bahwa para pencari keadilan itu, walaupun Mahkamah Agung sudah melakukan berbagai perubahan dalam kerangka akses to justice, misalnya pelayanan satu pintu, kemudian menghadirkan e-court litigasi, tapi rupanya perubahan-perubahan dan banyaknya laporan masyarakat itu masih menunjukkan masyarakat belum puas terhadap perkara yang mereka mintakan penyelesaiannya. Dan itu tugas kita semua. Oleh karena itu, terlebih-lebih dengan suasana pandemi, sekarang ini ada e-court litigasi atau sidang dengan virtual, maka tentunya itu secara konsepsi di bidang hukum, maka perlu ada suatu pemikiran yang brilian di para ahli hukum berkaitan dengan perubahan hukum acara, baik itu maupun data, sama bagaimana misalnya menilai suatu alat bukti atau keterangan saksi kalau itu dilakukan secara virtual, sistem barcode. Apakah perlu dibentuk lembaga pengesah bahwa suatu alat bukti itu memiliki tinggi atau asli dari asli. Nah, ini perlu pemikiran dari sisi aturan-aturan hukum. Kemudian juga dalam kasus-kasus perdata, lebih-lebih dengan, kalau saya perhatikan dengan undang-undang Cipta Kerja yang kemarin banyak menimbulkan debat di antara para ahli maupun masyarakat secara luas. Kalau saya perhatikan isu utama di dalam undang-undang tentang Cipta Kerja itu adalah persoalan investasi di Indonesia yang seringkali menciptakan suatu cost transaction yang terlalu tinggi sehingga daya saing lemah. Maka dalam undang-undang itu pemerintah berusaha bagaimana cost transaction itu tekan sehingga investasi di kita memiliki daya saing tinggi. Saudara-saudara baca Undang-Undang Nomor 11 Tahun 2020 ya, saya baca itu intinya banyak yang menyangkut perizinan dan berbagai kemudian berinvestasi terlepas daripada debatable tentang berbagai berbagai problem yang kemarin-kemarin itu kan debatable di antara para ahli hukum maupun masyarakat luas. Tetapi suatu isu yang sudah lama bahwa investasi di Indonesia itu adalah suatu investasi yang seringkali diklaim oleh para pelaku usaha itu menimbulkan transaction cost. Ada berbagai sebab, investasi, penegakan hukum. Nah, oleh karena itu kalau seandainya penegakan hukum di pengadilan itu semakin predictable atau dapat dipastikan bagaimana arah penegakan hukumnya, arah pencari keadilan itu bisa dengan mudah proses memiliki suatu prediksi tentang keadilan atau kepastian yang akan terima terhadap perkara yang mereka serahkan kepada pengadilan untuk pengadilan memutus terhadap perkara yang diajukan. Saya kira itu inti-inti daripada peran Komisi Judisial dalam tata hukum dan akses terhadap keadilan yang masih perlu diperjuangkan dari waktu ke waktu. Mudah-mudahan Mahkamah Agung yang memiliki cita-cita di tahun 2035 memban visi peradilan yang agung itu bisa kita wujudkan. Itu dalam konvensi ini mudah-mudahan itu suatu gagasan-gagasan pembuatan hukum dan tata akses ini perlu kita perjuangkan. Praktek masih juga ada masyarakat yang belum puas terhadap keputusan pengadilan, terbukti dengan data yang saya sampaikan tadi, banyak laporan kepada Komisi Judisial dari waktu ke waktu. Saya berharap laporan baik ke Bawas dan pengawasan Mahkamah Agung maupun ke Komisi Judisial itu dari tahun ke tahun itu semakin berkurang. Nanti kalau semakin berkurang, masyarakat semakin percaya terhadap putusan yang mereka harapkan para hakim dari pengadilan, sehingga kalau seandainya ada hakim yang keliru, masyarakat berpendapat bahwa itu standar hakim, tapi mereka percaya bahwa tidak ada pelanggaran terhadap ukurannya dalam satu konsep negara hukum. Walaupun hakim itu memiliki keputusan tetapi harus akuntabel. Di mana mengukur akuntabilitasnya di Indonesia, pesan melalui pengawasan eksternal yang penting. Saya juga percaya kalau seandainya hakim itu sudah mempedomani kode etik dan pedoman perilaku hakim, misalnya dalam kode etik itu ada larangan untuk tidak bertemu pihak selama proses berperkara. Kalau dijaga, maka kecurigaan hakim itu misalnya menerima sesuatu dari pihak yang berperkara, lambat laun akan. Sekarang banyak gedung-gedung pengadilan yang sudah ditata yang penataannya itu memang di tingkat pengadilan 2B, 1B, kemudian 1A, 1A khusus, itu sangat variatif kelengkapannya, tapi lama-kelamaan mudah-mudahan dengan semakin sarana prasarana itu lengkap di dalam pengadilan, maka penegakan hukum yang salah satunya ditopang oleh sarana yang memadai, maka lambat laun akses ke justice akan maksimal bisa dilakukan di Indonesia. Itu yang didorong oleh Komisi Judisial dan semua tentunya dalam rangka masyarakat itu bisa diwujudkan dengan saya kira itu sebagai keynote speech. Mudah-mudahan apa yang saya sampaikan ada manfaatnya. Terima kasih. Bila taufiq wal hidayah. Assalamualaikum warahmatullahi wabarakatuh. Saya kembalikan kepada moderator pembawa acara.
Okay, thank you, Mr. Dr. Jaja Ahmad Jayus SHMU, who become keynote speaker in this evening.
So, Dr. Jaja Ahmad Jayus SHMU will deliver as the keynote speaker entitled The Judicial Commission in Justice and Access to Justice. Briefly, that whereas by changing court proceedings using technology, there has been a shift in studies in the field of procedural law. Therefore, we need a work that is able to answer the evidentiary process based on procedural law that has been adhered to in both the Criminal Procedure Code and the Civil Procedure Code. Likewise, in the world of government, the legal rules are burdensome and can result in too high transaction costs, having to adjust to the development of the Industrial Revolution 4.0. So, that in the perspective of justice seeker and justice seekers ultimately resting in court can feel substantive changes from these rules. In turn, access to justice will be implemented properly.
And now we would like to give virtual certificate for Dr. Jaja Ahmad Jayus SHMU. Here the certificate.
One, to all of invited guests in this room can leave this event if you have another agenda.
Before that, thank you for coming, Vice of Rector Universitas Jenderal Sudirman, Dean Faculty of Law, and all of the VIP guests, Chief of Pengadilan Negeri Purwokerto, Chief of Pengadilan Agama, Chief of Kejaksaan Negeri Purwokerto, and another VIP guest. Thank you very much. Thank you for your coming.
The Faculty of Law, Jenderal Sudirman University, is one of the leading law faculties which is located on Professor Dr. H.R. Bunyamin Street, number 708, Purwokerto, Banyumas, Central Java, Indonesia. The Faculty of Law, Jenderal Sudirman University was established through a wire letter dated May 13, 1981. From the Director of Academic Facilities Development on behalf of the Director General of Higher Education, Ministry of Education and Culture. The Faculty of Law, Jenderal Sudirman University then began accepting new students in 1981-1982 academic year. Furthermore, based on Presidential Decree number 50 of 1982, the Faculty of Law officially became one of the faculties in Jenderal Sudirman University. The Faculty of Law, Jenderal Sudirman University, as the implementing element of higher education that carries out academic education, takes an important role in participating in the earning of direction and goals of development in the field of law by providing professional and competent law graduates. Therefore, the planning of the Law Studies Development Program must receive serious attention, which always refers to continuous quality improvement. Approximately 39 years of existence, the Faculty of Law, Jenderal Sudirman University has developed rapidly and followed times in an organizational structure that continues to work consistently. This development is inseparable from the contribution of the entire academic community from year to year in a structured manner. In 2020, the organizational structure of the Faculty of Law, Jenderal Sudirman University is led by Professor Dr. Ade Maman Suherman, SHMSC, as the Dean.
Assalamualaikum warahmatullahi wabarakatuh. Perkenalkan, saya Profesor Dr. Ade Maman Suherman, SHMSC, Dekan Fakultas Hukum Universitas Jenderal Sudirman. Dalam kesempatan ini, saya menyampaikan beberapa hal terkait dengan Fakultas Hukum Unsud, bahwa Fakultas Hukum Unsud sejak berdiri tahun 1981 saat ini sudah mengalami kemajuan yang signifikan dalam berbagai hal. Dalam usia yang ke-39 tahun, Fakultas Hukum Unsud berkomitmen untuk membangun pembangunan hukum nasional yang berkeadilan dan juga menitikberatkan kepada pembangunan akhlak, karakter, sehingga bisa membackup pembangunan hukum nasional ke arah yang lebih adil, sejahtera, dan bermanfaat bagi masyarakat. Assalamualaikum warahmatullahi wabarakatuh.
Dr. Setia Wahyudi SHMH as Deputy Dean for Academic Affairs.
Saya Setia Wahyudi selaku Wakil Dekan Bidang 1, yaitu Wakil Dekan Bidang Akademik.
Dr. Nur Indriati SHMH as Deputy Dean for Finance.
Saya Nur Indriati selaku Wakil Dekan Bidang Umum dan Keuangan.
Dr. Kartono SHMH as Deputy Dean for Students and Alumni Affairs.
Saya Kartono, Wakil Dekan 3 Bidang Kemahasiswaan dan Alumni.
The leadership of the Faculty of Law Jenderal Sudirman University brought out the vision that in 2025, the Faculty of Law would excel at the national level in the implementation of education and development of law science based on moral values, local wisdom, and the global competitiveness. To achieve this vision, Faculty of Law Jenderal Sudirman University compiled a missions. They are: first, organizing legal education according to academic standards with the good moral integrity to provide graduates who are highly competent, professional, and globally competitive. Second, researching with a roadmap that is consistent and oriented towards the development of legal science and benefit to society and national development. Third, organizing community service based on the competence of lecturers and or students to help overcome problems that exist in society and support national development. Fourth, developing collaborative activities and building networks with various parties at the regional, national, and international levels relevant to the three dharma of higher education. Fifth, carry out monitoring and evaluation and follow up on the results consistently to maintain and or improve the quality of the process and output of the three dharma of higher education. These vision and missions are made to achieve all stated goals and objectives. Faculty of Law Jenderal Sudirman University held 5 study programs. They are the undergraduate study program of law, which is divided into regular law and international law, the Master of Law study program, the postgraduate study program of notary, and the doctoral of law study program. In order to support existing student activities, the Faculty of Law Jenderal Sudirman University built facilities such as Justitia 1 building as the center of lecturing activities, Justitia 2 building as the center for administrative activities, Justitia 3 building as the center for joint activities, Justitia 4th building as the center of student activities. These facilities are optimized with our supporting program such as Law Laboratory Program, Law Journal which is divided to Legal Dynamics, Legal Idea, Authentica, Sudirman Law Review. Then the Study Center program is divided into 5 units. They are Center for the Study of International Humanitarian Law and Human Rights, Unit of the Center of Legal Studies and Regional Partnership, Constitutional Studies Center Unit, Small Business Law and Protection Business Center Unit, and Anti-Corruption and Money Laundering Research Center Unit. Conference program, namely the International Conference on Law, Government and Social Justice. This conference is a forum for scholars, researchers, and stationers to exchange ideas, research results, and experiences in dealing with current issues regarding the challenge of law, governance, and social justice. Relation Office programs. It is a collaborative program with cross-border law faculties to optimize legal education by global legal developments. The Faculty of Law Jenderal Sudirman University provides space for students to channel their interests and talents through student organizations such as the Student Executive Board, the Student Legislative Council, as well as 14 student activity units in the academics, non-academics, spiritual, and cultural fields. The Faculty of Law Jenderal Sudirman University also has several awards. They are Student Paper Weeks, moot court competition, and English debate competition. As an academic community, the Faculty of Law Jenderal Sudirman University will always hold on to the enthusiasm of working to make this faculty better in the future, as in line with our motto, keep moving forward and never give up. The Faculty of Law Jenderal Sudirman University is one of the leading law faculties which is located on Professor Dr. H.R. Bunyamin Street, number 708, Purwokerto, Banyumas, Central Java, Indonesia. The Faculty of Law Jenderal Sudirman University was established through a wire letter dated May 13, 1981. From the Director of Academic Facilities Development on behalf of the Director General of Higher Education, Ministry of Education and Culture. The Faculty of Law Jenderal Sudirman University then began accepting new students in 1981-1982 academic year. Furthermore, based on Presidential Decree number 50 of 1982, the Faculty of Law officially became one of the faculties in Jenderal Sudirman University. The Faculty of Law Jenderal Sudirman University, as the implementing element of higher education that carries out academic education, takes an important role in participating in the earning of direction and goals of development in the field of law by providing professional and competent law graduates. Therefore, the planning of the Law Studies Development Program must receive serious attention, which always refers to continuous quality improvement. Approximately 39 years of existence, the Faculty of Law Jenderal Sudirman University has developed rapidly and followed times in an organizational structure that continues to work consistently. This development is inseparable from the contribution of the entire academic community from year to year in a structured manner. In 2020, the organizational structure of the Faculty of Law Jenderal Sudirman University is led by Professor Dr. Ade Maman Suherman, SHMSC, as the Dean.
Assalamualaikum warahmatullahi wabarakatuh. Perkenalkan, saya Profesor Dr. Ade Maman Suherman, SHMSC, Dekan Fakultas Hukum Universitas Jenderal Sudirman. Dalam kesempatan ini, saya menyampaikan beberapa hal terkait dengan Fakultas Hukum Unsud, bahwa Fakultas Hukum Unsud sejak berdiri tahun 1981 saat ini sudah mengalami kemajuan yang signifikan dalam berbagai hal. Dalam usia yang ke-39 tahun, Fakultas Hukum Unsud berkomitmen untuk membangun pembangunan hukum nasional yang berkeadilan dan juga menitikberatkan kepada pembangunan akhlak karakter sehingga bisa membackup pembangunan hukum nasional ke arah yang lebih adil, sejahtera, dan bermanfaat bagi masyarakat. Assalamualaikum warahmatullahi wabarakatuh.
Dr. Setia Wahyudi, SHMH, as Deputy Dean for Academic Affairs.
Saya Setia Wahyudi, selaku Wakil Dekan Bidang 1, yaitu Wakil Dekan Bidang Akademik.
Dr. Nur Indriati, SHMH, as Deputy Dean for Finance.
Saya Nur Indriati, selaku Wakil Dekan Bidang Umum dan Keuangan.
Dr. Kartono, SHMH, as Deputy Dean for Students and Alumni Affairs.
Saya Kartono, Wakil Dekan 3 Bidang Kemahasiswaan dan Alumni.
The leadership of the Faculty of Law Jenderal Sudirman University brought out the vision that in 2025, the Faculty of Law would excel at the national level in the implementation of education and development of law science based on moral values, local wisdom, and the global competitiveness. To achieve this vision, Faculty of Law Jenderal Sudirman University compiled a missions. They are: first, organizing legal education according to academic standards with the good moral integrity to provide graduates who are highly competent, professional, and globally competitive. Second, researching with a roadmap that is consistent and oriented towards the development of legal science and benefit to society and national development. Third, organizing community service based on the competence of lecturers and or students to help overcome problems that exist in society and support national development. Fourth, developing collaborative activities and building networks with various parties at the regional, national, and international levels relevant to the three dharma of higher education. Fifth, carry out monitoring and evaluation and follow up on the results consistently to maintain and or improve the quality of the process and output of the three dharma of higher education. These vision and missions are made to achieve all stated goals and objectives. Faculty of Law Jenderal Sudirman University has 5 study programs. They are the undergraduate study program of law, which is divided into regular law and international law, the Master of Law study program, the postgraduate study program of notary, and the doctoral of law study program. In order to support existing student activities, the Faculty of Law Jenderal Sudirman University built facilities such as Justitia 1 building as the center of lecturing activities, Justitia 2 building as the center for administrative activities, Justitia 3 building as the center for joint activities, Justitia 4th building as the center of student activities. These facilities are optimized with our supporting program such as Law Laboratory Program, Law Journal which is divided to Legal Dynamics, Legal Idea, Authentica, Sudirman Law Review. Then the Study Center program is divided into 5 units. They are Center for the Study of International Humanitarian Law and Human Rights, Unit of the Center of Legal Studies and Regional Partnership, Constitutional Studies Center Unit, Small Business Law and Protection Business Center Unit, and Anti-Corruption and Money Laundering Research Center Unit. Conference program, namely the International Conference on Law, Government and Social Justice. This conference is a forum for scholars, researchers, and stationers to exchange ideas, research results, and experiences in dealing with current issues regarding the challenge of law, governance, and social justice. Relation Office programs. It is a collaborative program with cross-border law faculties to optimize legal education by global legal developments. The Faculty of Law Jenderal Sudirman University provides space for students to channel their interests and talents through student organizations such as the Student Executive Board, the Student Legislative Council, as well as 14 student activity units in the academics, non-academics, spiritual, and cultural fields. The Faculty of Law Jenderal Sudirman University also has several awards. They are Student Paper Weeks, Moot Court Competition, and English Debate Competition. As an academic community, the Faculty of Law Jenderal Sudirman University will always hold on to the enthusiasm of working to make this faculty better in the future, as in line with our motto, keep moving forward and never give up.
Welcome back to ladies and gentlemen. And now we come to the main program, plenary session 1, that will be delivered by our speakers. First, Professor Dr. Thomas Smith, DEAD lecturer at Universitas Gajah Mada and adjunct professor at the University of Göttingen, Germany. Second, Professor Dr. Nazura Abdul Manap from University Kebangsaan Malaysia. And third, Professor Dr. Ade Maman Suherman, SHMST from Universitas Jenderal Sudirman. And this session will be moderated by Mr. Manunggal Kusuma Wardaya, SHLM. and this is his curriculum vitae.
Mr. Manunggal Kusuma Wardaya, SH LLM, was born in Surakarta, March 24, 1975. His educational background: first, Bachelor of Law, Faculty of Law, Universitas Jenderal Sudirman on 1998. Second, Master of Law on International and Comparative Law at Monash University, Melbourne, Australia on 2005. Third, short on course Globalization, Labor Rights and Corporate Social Responsibility Institute of Social Studies, Erasmus Universiteit Den Haag, Netherlands on 2005. And last, PhD candidate at Radboud University, Nijmegen, Netherlands.
And now we invite Mr. Manunggal Kusuma Wardaya, SLLM, to lead this session. Time is yours.
Assalamualaikum warahmatullahi wabarakatuh. Good morning, everyone. And special guest and followed by a series of presentations in the panel session starting from today and ended tomorrow. Well, as you can see now, I'm now with Mr. Ade Maman, the Dean of the Faculty of Law, but I'm also accompanied actually with another speakers. The first is Mr. Thomas Schmidt from Germany. He's online now. Mr. Thomas, where are you? Good morning, Mr. Thomas. And
yes,
we will have also, yeah. Hello? Can you hear us? Yeah. Apa kabar?
Baik.
Yeah, nice to see you, Mr. Thomas. From Germany, but he's not in Germany actually now. Mr. Thomas is a PhD lecturer and is currently in UGM, or University of Gajah Mada, Yogyakarta. The second speaker will be Mrs. Nazura Abdul Manap from UGM, University Kebangsaan Malaysia. Hello, Mrs. Nazura.
Hi, Assalamualaikum. How are you?
Salam. Hope you are doing well. And last but not least, my boss, Mr. Ade Maman Suherman from Faculty of Law, Sudirman University of Purwokerto. How are you, Mr. Maman? Yeah. We have wonderful people here to share their ideas. And for the first speaker, we will give the time to Mr. Thomas Schmidt. He has a very long, biography or curriculum vitae. I cannot read all of them. It will be too long, and some of them are written in German, which I don't understand. So I will read a brief of his curriculum vitae. Mr. Thomas Schmidt received his doctorate degree in law in 1989. Yeah. And he's now a adjunct professor of the University of Göttingen in Germany. And his field of expertise are European law, in particular EU internal market law, fundamental rights, constitutional law, administrative law, and also many other areas of law. As I told you just now, Mr. Thomas is currently a DAAD lecturer at the University of Gajah Mada since 2019, if I'm not mistaken. And he held the same position before at the Faculty of Law, University of Hanoi. Today, ladies and gentlemen, Mr. Thomas will be delivering a paper entitled COVID-19 Response and Human Rights, comments from the German and European perspective. So I think it's very up-to-date topics that we can learn from Mr. Thomas. I'm not going to take the time too much, so Mr. Thomas, you have 30 minutes to present your papers. The time is yours. Thank you.
Thank you very much. You can see my paper now, right? So can you hear me? Okay, so selamat siang. Oh, good. Selamat siang, dear moderator, dear rector, dear dean, dear chairman, and dear organizing committee, and dear ladies and gentlemen. I am very proud to have the possibility to speak here at the conference of Universitas Jenderal Sudirman. I hope that I could go myself to Purwokerto and visit the colleagues there, but due to the pandemic, this needs to wait. Maybe next year after the pandemic. Since I'm living and working in Yogyakarta, it's not a long way, so I hope the chance will come again. I'm impressed by the impressive program of this conference and also by the very professional preparation. But I see there are many, many people participating, so it will be an interesting conference. My topic is a very topic. COVID-19 restrictions and human rights. That is a question of law, not just of politics. The pandemic is no excuse for watering down the rights of the human being. Modern human and fundamental rights doctrine allow precise and accurate assessment of the legality of any measure to fight COVID-19. In the states, based on the rule of law, this is usually the mission of the courts. They need to enforce the human and fundamental rights, even against COVID-19 restrictions. In Germany, until October 2020, we had already more than 220 relevant court decisions just on that topic. Now, before I actually go into details, I would like to show you here. You can see my paper now. And this paper you can download from the link which is provided with the conference kit or from my website. And if you click on the parts which are underlined, you see that in my paper, some passages are underlined. There are links which will lead you to more information, to articles, court judgments, laws, and so on. So if you download this paper as a PDF file, you can get access to numerous materials. However, I will now change to a different paper, which is a little bit more simple. Now you should see, yes, this is more simple. There's my web address in Indonesia. You can download my paper there. And rights doctrine are interesting sources of inspiration in the global discourse about human rights. That's why I want to comment from the German and European perspective. This is due to the rich and sophisticated jurisprudence of the European Court of Human Rights in Strasbourg on the European Convention on Human Rights, but also due to the rich and sophisticated jurisprudence of the German Federal Constitutional Court, the most active constitutional court in the world. And finally, due to the innovative Charter of Fundamental Rights of the European Union, the most modern and up-to-date fundamental rights catalog in the world. However, let me first talk a little bit about terminology so that you are not irritated. Under the common international terminology, which is different from the Indonesian terminology, human rights are only the pre-legal, the natural rights of the human being, according to philosophical doctrine, and also the rights which are guaranteed in the international human rights treaties, who pretend just to reflect this philosophical doctrine. While the legal positions which have been created by the implementation of this philosophical doctrine into the constitutional law, they are usually called fundamental rights. So what you have in the Indonesian constitution, the chapter on human rights, dogmatically this is not human rights, it's fundamental rights. Something different. However, in the context of my lecture, most rules apply to human rights and fundamental rights in the same way. I will now talk to classical human and fundamental rights questions which are raised by the COVID-19 restrictions. Which are the rights affected? We first need to know that. And you see, there is an impressive list. First of all, there are severe restrictions on the freedom of occupation or profession and the freedom to conduct a business, because many restrictions practically amount to a temporary prohibition of certain professions or businesses, such as hairdresser, have been closed for several weeks in Germany, masseur, physiotherapist, airlines, hotels, bars, discotheques, and so on. These rights are seriously affected. Also, the freedom of physical movement is affected by travel restrictions, curfews, closures of public squares, parks, and beaches. If the restrictions prevent you from meeting your spouse or your children, which has happened in Europe, they also affect marriage and family life. The personal freedom, liberty, is affected in case of quarantine measures which oblige the citizen to stay at one place for 2 weeks. The freedom of assembly is affected by bans on gathering in large crowds. This makes it impossible to exercise an essential right which is constituted for democracy. The freedom of religion is affected by bans on gathering for public worshipping. The freedom of arts is affected by bans on public concerts or the forced closure of museums and galleries. For example, Yogyakarta is suffering a lot under these restrictions. Just a couple of weeks before the pandemic arrived, we had a big rock festival with the Scorpions and Whitesnake playing in Yogyakarta. All this is not possible. Freedom of science is affected. That means we all are affected because of the forced transition to online teaching. This is affecting our freedom, of course. The protection of or the respect for family life, these are just two different names in German and European law for the same, family life, is restricted by restrictions on family gatherings, wedding receptions, funerals. The right to the protection of personal data, or as the Germans say, the right of informational self-determination, is affected in case of compulsory testing or contact tracing. In the pandemic, the state needs to know who you have met, when and where. That's very sensitive. There are more rights affected. For example, in Germany, we have a general freedom of action, the right to do or not to do any activity you want. This right is affected by the compulsory wearing of face masks, by contact restrictions, sport restrictions, or the limitations of private parties. Virtually, any freedom right and most other human rights can be affected by the COVID-19 restrictions. This is quite tough. Usually, these restrictions encroach on these rights by prohibition of certain activities, but can also be by issuing of conditions for activities. For example, the order to follow health protocols, or even by specific official warning For example, a warning of the authorities not to attend public prayers at a certain mosque or church, or not to take part in a certain demonstration, or not to go shopping in a certain shopping mall, of course, affects also the concerned fundamental rights. The question is, however, are these encroachments justified by the limits of the affected rights? All human rights, all freedom has its limits. It's usually laid down in a specific limitation clause for the individual fundamental right or human right, or in a general limitation clause as you have that in Indonesia. These limitation clauses allow restrictions of the rights by law or based on law to protect the rights of others or to pursue certain overriding public interests. Which are the overriding interests protected by the COVID-19 restriction? And now we see it's quite heavy. We have first the fellow citizen's right to life, but also the citizen's right to physical integrity. That's how we call that in Germany, or the protection of health.
Ketika kami diminta oleh badan kajian DPR, jaksa ada di mana sih? Ada di eksekutif, ada di legislatif. Oh, sebagai lembaga yang ambigu, yang banci, yang tidak jelas posisi dan.
Sorry, is there a problem? Finally, we have public health, which is the most important issue. In particular, the state needs to prevent the collapse of the healthcare system, which would cause the death of numerous people. We had such a collapse of the healthcare system in Italy in spring. So it's quite serious. The COVID-19 restriction also protect other goods, even the economic well-being of the country. Let's be clear. COVID-19 restrictions have a double effect on the economy. They may hinder economic activity, but eventually they serve to sustain them during the pandemic. As the experience of the failure of President Trump in America shows, as long as the pandemic is not fought successfully, the economy cannot recover. We see that in Indonesia too. What is important is that all COVID-19 restrictions need to comply with the so-called limits of limits. Yes, human rights or fundamental rights are limited, but the limitation of the rights must be limited too. We call that the limits of limits, or the so-called Schranken. For example, there must not be an encroachment on the essence of the affected rights. For example, a total ban of political demonstrations for a longer period would practically destroy this right. It can never be allowed. The most important limitation, however, is the principle of proportionality. An important sub-principle of the rule of law, an element of any human or fundamental rights doctrine. So it's also in Indonesia. It derives from Article 1, Section 3, which says that Indonesia is a negara hukum. Either also Indonesian law knows the principle of proportionality, or Indonesia is not a negara hukum. So this principle is the most important, and we will discuss about it in detail later. It requires a legitimate aim for the measure. The suitability of the measure must be helpful to fight the pandemic. It must be necessary and proportional in the strict sense that means not be excessive. Furthermore, in the restriction, there must not be an unequal treatment. For example, it would not be allowed for the state to prohibit the Friday prayer in the mosque, because public gathering in the mosque is dangerous, but at the same time to allow the Catholic Sunday service in the church. That would be an unequal treatment. Let me now come to a serious other aspect, the second dimension of human and fundamental rights. The state is not only allowed to respect human and fundamental rights, it must also protect them against threats by private persons, but also against the threats by nature. The European Court of Human Rights has developed a doctrine of positive obligations. That means the state must engage actively in activity to secure the effective enjoyment of the human rights. The German Federal Constitutional Court has developed a rather similar doctrine of duties of protection, grundrechtliche Schutzpflicht. The state must not only respect fundamental rights, but also protect them by active intervention. In Germany, this obligation even derives from the guarantee of human dignity, the most important principle. However, there is a problem to define clear standards and to determine violations in complex situations such as the coronavirus crisis. The state necessarily has a wide margin of depreciation and discretion. But where are the limits? The European Court of Human Rights so far has not developed a general doctrine on that. The German Federal Constitutional Court came up with the idea of a prohibition of insufficient means, Untermaßverbot. That means the state must do enough. However, the contours of this prohibition of insufficient means, which complements the prohibition of excessive means under the principle of proportionality, the contours of this prohibition are still unclear. If you want to make big career in the field of human rights and fundamental rights, you write a doctoral thesis or habilitation thesis on that topic. After that, if you have brilliant ideas, you can choose your job as a professor everywhere in the world. However, numerous people have already tried that. In complex situations where different authorities at regional level or national level take various measures that complement each other and have a serious impact on economic, social, and private life, these doctrines allow only to identify obvious and serious failures of protection. I can give two examples. That is the premature easing of the lockdown in the American state Florida and in the Indonesian province East Java. The easing of the lockdown despite soaring infection and rising fatalities. So that was a clear example. When they eased the restrictions, because they had planned that before, even when the numbers of infections were imploding, the governments, the regional governments, they caused the death of numerous people. However, such examples are very rare. So in most cases, these theories of duties of protection or positive obligations have another function. They are important for the assessment of the proportionality of the COVID-19 restrictions, for the balancing of the restricted and the protected rights. We must both keep in mind. There is another horrible special problem, but I cannot talk about that. This would be not the topic of a special lecture, but of a whole conference. Does the legislator need to pass a regulation on coronavirus triage? That means, does the law need to regulate how the doctors select whom to protect and whom to save and whom to let die when the hospitals are overwhelmed? This is a very special, horrible problem. Now let's come to the problems of proportionality, more in depth. We need an individual examination of the individual measure as such and in context with regard to the specific circumstances of place and time and to the available epidemiological expertise. A general assessment like a lockdown is allowed or not is not possible. Identical measures in different countries, regions or cities at different phases of the pandemic or under different knowledge about the virus may need to be evaluated differently. For example, a business lockdown need to be shorter in countries without a social security system than in Europe, where you have developed social security. Measures that were proportional at one time may be unproportional at another time, and vice versa. For example, a second lockdown is more difficult to justify than the first lockdown, considering the growing knowledge, experience, and alternatives. The first aspect of proportionality is the legitimate aim. This is to fight the pandemic, to protect the life and health of the fellow citizens, public health. It's not the problem. However, it would not allow to prohibit demonstrations if this prohibition in reality just serves to prevent criticism of the government and not to fight the pandemic. That's an example. The suitability of the restriction means that the measure must be conducive, helpful to fight COVID-19. The authorities who have the experts at their side, they enjoy a wide margin of appreciation and evaluation. That means the lawyer is not allowed to replace their assessment by his own one. The courts can only check if the assessment of the authorities is tenable. Is it reasoned? Concerning the suitability, there were doubts about mandatory mask wearing. This has been cleared up by science. In my paper, I give you 3 examples of higher administrative court decisions which declare mandatory mask wearing a suitable measure to fight COVID-19. Bigger problem is the necessity. The measure must be the last intrusive act of intervention that is equally conducive. There must not be a milder alternative. There's also a margin of appreciation and evaluation here. For example, there must not be any obligation to wear a face mask when you are alone in the car. This is an example, I think I read that from Jakarta. There was a regulation which says in the car you must wear a face mask. This is excessive. It would be enough to prescribe the citizen to close the car window if he is not wearing a face mask, if he is alone in the car. You see, this is an example. Or measures must be limited in time. Increasing duration requires increasingly sustainable, fact-based evidence of risks. Most important is that comprehensive prohibitions are not allowed if targeted restrictions are sufficient. For example, the human and fundamental rights do not allow a ban of public demonstrations of religious events if precautions and special health protocols can avoid the infections and compliance is ensured. This was decided by the German Federal Constitutional Court in the case about a total ban of Friday prayers in German mosques. So the Muslim community fought and they were successful. This decision of the German Federal Constitutional Court, which was initiated by the Muslim community, also paved the way to resume Christian church services. Now, the religious services are possible again, but with health problems. Or, another example, there must not be a general ban of drive-in cinema shows, even with large audience, because when they are in the drive-in cinema, they are inside the car, they are insulated from each other, there is no risk of infection. Such a measure is not necessary. Limitations of wedding parties to 50 participants have been considered necessary by the courts because a party typically leads to closer physical contact of a larger number of persons. And physical distancing, or what we call social distancing, is not possible in practice. So in Germany, it has been made clear wedding parties can be restricted. Special restrictions for vulnerable groups, however, are not conducive. They are not an alternative to general restrictions. You cannot just put measures to protect the old and the sick, because everybody can spread the coronavirus and can suffer from the coronavirus. The problem is, if it was necessary to close the borders with little affected neighboring states in Europe, within the European Union, this will be a big topic in the future. I think it was not. Now we come to the proportionality of the restriction in the strict sense. The burden must not be out of proportion to the aim in view. This requires a thorough balancing, and the state's duty to protect life and health justifies even very severe restrictions. Exceptions from general rules or accompanying state support measures, as we had that in Indonesia or in Germany, can be helpful to avoid excessive borders. That means if the businesses suffer or people cannot make their earning, but the state supports them, for example, financially, this can make the burden lower. There are two problems. Was it proportional to sustain travel restrictions which separated unmarried life partners over a long period of time? We have that in Europe. So many couples are living together, sometimes even for the whole life, without being married. In the restrictions, there were no exceptions for that. This was probably a violation of human rights. And a more serious problem. Was it proportional to keep patients in the hospital who are dying in absolute isolation, separated from families and friends? Now we say no. This was the practice in Europe, and I think in Indonesia too. They did not allow the families and the friends to meet these patients because the risk of infection was high. However, these patients died. Lots of them, they could not see their husband or their wife anymore, their children. So I think this was unproportional. This was a violation of human fundamental rights. Nowadays, the hospitals are looking for other solutions. For example, to have special meeting rooms with a glass window in between and a speaker system where the patient and the families can talk, can say farewell to each other, because the patient knows that he will die. And they can do this in a human way without spreading the infection. Ladies and gentlemen, these are just some examples of the numerous problems which are already discussed in Europe. There is a need for a permanent, critical monitoring and discussion. We must always keep both dimensions of human rights in mind. The freedoms on one side, but also the state's duty to protect the life and the health and public health on the other side. There should be one solution, that is scientific progress. it will help. I just would like to give you one example which would destroy all my lecture here. A reliable and cheap ad hoc coronavirus test. That means a test which is not a joke, like the present test in Indonesia, but a test which delivers results immediately, which are true in 99% of the cases. Such a test would allow to ensure virus-free venues and events. You could have meetings of large crowds again by simple entrance controls. So, if we had such a test, for example, most COVID-19 restrictions would be obsolete, because this test would be the milder alternative, which makes them not necessary anymore. The vaccination will help too, but I'm afraid that the pandemic will still go on for a while, even when the vaccination is accessible. And so the discussion about COVID-19 response and human rights will go on too. Thank you very much for your attention.
Your own place, yeah. Thank you, Thomas. Very impressive presentation about COVID-19 and its impacts to human rights. Ladies and gentlemen, as explained in the presentation, so many freedom and rights are affected by COVID-19. Yeah. Even this conference, this academic event, as also discussed by Thomas just now, we organized this in our hall in Unsud, Purwokerto, and we have to make sure that there are enough space for people to keep their safe distance. Yeah. Another interesting point is that Thomas reminded us about the state obligation to protect human rights, and that the pandemic, the COVID, is not an excuse for the states to escape from their obligation to protect, to respect, and to fulfill human rights. Although from that point also new problems arise. Yeah? How, to what extent the state can infringe or to reduce the rights and freedoms, the enjoyment of rights and freedoms of the people and any individuals within its jurisdiction. Ladies and gentlemen, we will move forward to the presentations of Ms. Nazura Abdul Manap. And before we listen to her presentation, let me read the curriculum vitae of Mrs. Nazura Abdul Manap. Mrs. Nazura is Associate Professor of Law, an accredited mediator, Malaysian Bar Council. So many publications has been written by Ms. Nazura Abdul Manap. I will be reading some of them. The first, like cyber terrorism challenges, the need for a global response to a multi-jurisdictional crime. Another publications published in International Journal on Advanced Science, Engineering and Information is an article entitled Electronic Records Management System Adoption, Readiness Framework for Higher Professional Education Institutions in Yemen. The third publication and not the last publication is Bringing Life to Folklore, Problem of Definitions. Ladies and gentlemen, Ms. Nazura will be presenting her paper entitled Copyright Tribunal in Malaysia, the New Paradigm. It's a very interesting title also about Copyright Tribunal. It's not only Human Rights Tribunal here, that we all often hear maybe, but also Copyright Tribunal. Before we, yesterday we, in the, what you call it, technical meeting, there was a suggestion to, to play some music in between sessions, yeah. But we were reminded that copyright issue that might occur, so we decided not to play any music and just a slide about our profile, faculty profile like that. Ladies and gentlemen, Miss Nazura is now with us. Hello, Miss Nazura.
Yes, I'm
yeah?
here.
Okay, the time is yours.
Thank you very much. I think I should share screen, yeah, now. Okay, I hope that everyone can see the, where is it? I cannot see the screen, the sharing screen. Okay, it takes time.
Perfect.
All right. Okay, now, yeah. Okay, Bismillahirrahmanirrahim. Thank you, Mr. Moderator, for the kind introduction. The respectful Dean of Fakultas Hukum University Jenderal Sudirman, Prof. Ade Manan, my good friend, yeah. The fellow panelists and all the participants that are here today. Assalamualaikum warahmatullahi wabarakatuh, and very good afternoon. It's afternoon already, yeah, here in Malaysia. And first and foremost, it is my pleasure to be here with all of you today in this lovely conference on law of governance and social justice 2020. Yeah? I would like to congratulate the organizer for successfully organized this meaningful event. Yeah? It's a very good event. And also to thank the ICOLGAS organizer for having me invited to share information and experience in my chosen topic. Yeah? The reason why I chose this title is because this is the current development in copyright law in Malaysia. Yeah, that our law, which is the Malaysian Copyright Act 1987, has been amended in this year, yeah, early this year, and just being enforced. Yeah, and it is my hope that this sharing would attract responses, yeah, from the participants to also share with me the position of same matters in your jurisdictions. Yeah. All right. Without further ado, I now start my presentation. Okay. The topic of my presentation today, as you can see on the screen, is Copyright Tribunal in Malaysia, the new paradigm. Okay. Right. This topic, this presentation will be guided by the agenda, which is first introduction, yeah, second is on collecting societies, so that you will know what is it, the title that will be discussed today. Collecting societies as licensing bodies in Malaysia. The third one is seeking justice from Copyright Tribunal. We are looking at the Copyright Tribunal in the perspective of Copyright Act 1987, and also the position of Copyright Tribunal in Australia as the selected jurisdiction, and also the conclusion. Okay. Then, okay. Hold on, yeah. Okay. Right. So, the aim here of this presentation is to discuss the roles, yeah, the roles of the Copyright Tribunal in assisting to settle dispute between licensing bodies or collecting societies, or also known as CMO, Collective Management Organization, and the members, as well as to determine issues brought about by the users of copyright works, yeah, or copyright licensee. Okay. I try to okay. I cannot control my slides. I thought I can control my slides. Okay. So just to share you some royalty issues that actually occur in Malaysia for past few years. Yeah, you can see that in this presentation, the issue of confusion over the collection of music royalties seems to be no longer a problem, yeah, with the establishment of Music Rights Malaysia Berhad, which is also known as MRM. This non-profit organization is the sole licensing body that has been tasked with the responsibility of fee collection in Malaysia, in this country. Yeah? This non-profit organization is also known as Collecting Society or Collective Management Organization, or CMO. Okay, next one. Okay, just to share with you a bit of a story, yeah? What actually happened in Malaysia. In 6 October 2020, the Malaysian Artists Association, or also known as Karyawan, is to seek the intervention of the Malaysian Anti-Corruption Commission, yeah, in a dispute over some ringgit Malaysia 30 million in unpaid royalties for recording artists. So meaning that there is an issue of non-payment, yeah, by Collecting Society to the artists. Karyawan President, who the picture is on the screen, Mr. Freddy Fernandez, said he was dismayed, yeah, by the possibility that several hidden hands, yeah, might have manipulated the collection of royalties for their own gain. Yeah, Mr. Fernandez, a member of the MACC advisory panel, said he will ask the anti-graft agency to conduct checks on the 4 companies involved, which are the CMO. They are Public Performance Malaysia, PPM, representing recording companies, Recording Performers Malaysia Berhad, RPM, and Insolvent Firm Performers Right and Interest Society of Malaysia Berhad, PRISM, MACP, which is Music Authors Copyright Protection Berhad, which acts for composers and publishers of music. So, Mr. Fernandez think that these people, yeah, has abused, yeah, the money belong to the artists. Yeah, this shows that the dissatisfaction among artists relating to the issue of royalty. Okay, next, please. Okay, I know Indonesian are very familiar with this name, yeah, a famous singer of Sheila Majid. Yeah, Sheila Majid, or also known as Datuk Sheila Majid in Malaysia, received a check only for RM5,000 as royalty payment for her songs that have been playing on the radio and in public places. It was her first ever check, yeah, for royalty payment. You just imagine, Sheila Majid has been singing for years, I think nearly 30 years, but she just got 5,000 for the royalty. Yeah, she says she received it all of sudden when she started talking about setting up Recording Performers RPM Malaysia Berhad, a new body to collect and distribute royalty for commercial recording performers, which is for singers and musicians. After 10 years or so, she said, they, Prism Sdn Berhad, gave me a check for RM5,000, but with no statement showing how they arrived at that figure, she says. Yeah. So what actually happened here? Okay, what happened? Yeah. It seems that there is no proper monitoring system by the government, yeah, which actually caused the CMOs not to do their responsibility as they should be. This leads to abuse of power and money, which caused the unfair distribution of royalty. Yeah. So this, I just try to make all of you understand why is it this topic of copyright tribunal very important nowadays. Yeah. Okay, just to share with you the next a little bit on the history of collecting societies or CMO in Malaysia. In 1988, the first collecting society in Malaysia was represented to administer the public performance rights of sound recording was the Pornographic Industry Southeast Asia Sdn Bhd, or also known as PPM. The Music Authors Copyright Protection Berhad, MACP, was incorporated the following year to administer the distribution rights of musical and related literary works, as well as the public performance and broadcast. Yeah. So a little bit on the history. The next one would be, what are the collecting societies or the collective management Okay, the next one, what are the collecting societies or collective management organization or CMO? Okay, it is an association, yeah, or entity that is established to negotiate and issue copyright licenses, yeah, for and on behalf of copyright owners, yeah, and they are also referred as licensing body, yeah, under the Copyright Act 1987. Okay, essentially the licensing body grants licenses and collects royalties on behalf of its members who are the copyright owners. So the copyright owners can be the composers, yeah, the singers, the actors, or the performers. Yeah. A licensing body referred to in Section 3 of the Copyright Act 1987 implies a corporation or an entity deemed under Section 27A of the Act to be a licensing body. So this is actually being statutorily interpreted, yeah, in our Copyright Act 1987, and it was actually also decided, yeah, in the case of Public Performance Malaysia Sdn Bhd and another, and Prism Berhad. Yeah? Okay, the next one would be how to be a collecting society. Okay, in order to be a collecting society, yeah, any corporation or entity that wishes to act as a licensing body for copyright owners or for a designated class of copyright owners, yeah, can actually apply to the copyright controller to be considered a licensing body. Okay, so they can be a CMO. Yeah, each licensing body functions within the context of its own licensing scheme. So it depends whether they are handling, yeah, an entity relating to music, yeah, or films, yeah, or perhaps performance. Yeah. Okay. Next one would be how to be, okay, what are the current CMOs or collective management organization that we have in Malaysia? The first in the list is MACP, which is also known as Music Authors Copyright Protection Berhad. They are representing composer and lyricist, which is declared on 28 September 2012, and they are still valid until today. Yeah? PPM, Public Performance Malaysia Sdn Bhd, representing recording companies. They are declared to be a collecting society on 5th March 2013 and valid until now. And Recording Performers Malaysia Berhad, RPM, representing singers and musicians of sound recording. They are declared as licensing body or CMO on 6 March 2013. Okay. Now, in the next slides, okay, this is a specific provision under Copyright Act 1987. Yeah, particularly in Section 227A, this provision has been amended to mandate, yeah, any corporation or association that wishes to act as a licensing body for copyright owners to apply to the controller of copyright. So this amendment, yeah, has been done, yeah, in 2012. And this controller of copyright, yeah, is also known as Malaysian Intellectual Property Office, or MYIPO. Yeah? And with the enforcement of the regulations on 1st June 2012 all current and prospective licensing bodies shall apply for the controller's declaration to act as collective licensing bodies on behalf of their members. So now, once they've been appointed as licensing bodies or collecting societies, then they can act on behalf of, they can actually collect the royalties or the payment on behalf of the members. And okay, at that point of time in 2012, the government didn't actually really develop a specific monitoring system whereby actually the government leaves the matters on royalty rate to the parties concerned to decide based on the agreed contractual terms. This actually, as I have mentioned during my previous slides, can cause problems in terms of abuse of power. Because some people, like what I just shared with you, Sheila Majid has just got only ringgit Malaysia 5,000 ringgit for the, I just couldn't believe it. It's just for 20 over years being in the music industries. Right. The next, okay, now we come to the issue of copyright tribunal. Why is it we need copyright tribunal? Why is it this year suddenly the government cares to amend the Copyright Act actually to suit the role of copyright tribunal? The first one, because of this copyright tribunal is empowered to determine the licensing terms. It can be done by both parties. But then if anything happen to the agreement, it can be being brought up to the copyright tribunal to be settled. Okay. And then the second one is to settling disputes. The role of copyright tribunal, this type of role of copyright tribunal, is very important because there are issues amongst or between licensing operator, which is the CMO, and also the licensing operator and licensing applicants, MAIPO and also the CMO, and that also can be referred to the tribunal because the tribunal is an independent body. And if there is any refusal of license from let's say someone applies a license to CMO, for example, or someone applies a license to someone else, or applies a license to translate, a certain written materials which has been published in other languages, then it can be brought to the copyright tribunal in Malaysia. Okay. Next one. Okay, why? I mean, most of the countries in the world, they have available justice system, which is also known as court. But why is it we have to seek justice from copyright tribunal? Among reasons, is because it could provide quicker, cheaper and easy access to justice, necessary for the administration of welfare programs involving a larger number of minor claims, while the judicial process is elaborate, slow and expensive. So this is I mean, the main reasons why there are actually a lot of problems happen in entertainment industry, but they did not bring it to court of law because of that problem, because of those problems. And the Copyright Tribunal is an independent body established under the Copyright Act 1987 with the principal task to adjudicate disputes between collective licensing agencies and the persons, any interested persons, in a situation whereby the parties are not able to agree between themselves over terms and conditions of copyright licensing and royalty payments. Yeah, those are among reasons, main reasons why they bring the case to the copyright tribunal. All right. Next one, I just want to show you, why not court? Yeah, you can see the difference. Yeah, the tribunal, the process is more cheap and fast, whereas court is expensive and slow. Yeah, because you have to hire lawyers, you have to go through so many procedures, and it end up to be a very long process. Yeah, and the process and procedure for tribunal is informal process, whereas in courts is very strict and rigid rules. So this is also things that create hurdles, for interested people to bring their case to the court of law. And the most good thing about tribunal is normally in tribunal it will be presided by expert people, expert person, But in court is not necessary. A person that is an expert in certain matters to be what do you call it, presided in for that particular case. Yeah. Okay. The next one, I would like to share with you the copyright tribunal structure in Malaysia. It is actually being had by a chairman and being assisted by the deputy chairman. Yeah, and apart from chairman and the deputy chairman, there are members of tribunal. There are, for the time being, eight of them. Yeah, 2 chairman and deputy chairman. Another 6 actually is the members of the tribunal, and the tribunal is also assisted by the secretary of tribunal, and they are all public servants and holding office for a period not exceeding 3 years, after which they shall be eligible to be reappointed. Yeah, if the minister, and it is normally being appointed by the minister. Yeah, right. The next one, just to share you the interested parties. Yeah, that normally will they are very relevant to the matters in copyright tribunal. First is performer under Section 16B of Copyright Act 1987, which include actors and actresses, dancers, singers, musicians, or any person who performs a performance. So they are also very relevant to the copyright tribunal. Yeah. And the next one would be the operator, a person or an organization under Part 4A in the Copyright Act 1987, which actually represents licensing body scheme, which is currently running a licensing provided to any individual or company, which is the CMO. Yeah, the CMO. The next one, which is also a person in need. Yeah. A licensing body whose declaration was withdrawn. Yeah, for example, they've been appointed and suddenly they withdrawn by MIPO, for example, and that can be appealed to the tribunal. Yeah, and the fourth one is people that exercise under the power under Section 31, whereby, as I mentioned before, it applies for a license in Malaysia to produce or publish translation of a literary work. For example, we have books, or written materials from other countries in Malaysia, which is in different language, like perhaps in Japanese or Korean. Yeah. Then when it comes to Malaysia, if let's say someone would like to translate the books, for example, if they cannot get the permission from the owner of the copyright, they can actually turn to the copyright tribunal to get that particular permission. Yeah, that is one of the power. Yeah, and Section 559C is the recent amendments to Copyright Act 1987, whereby it grants additional powers to the Copyright Tribunal to settle royalty conflicts between the CMO and the representative, yeah, the artists or singers, yeah, or musicians, right? So the next one, okay, and okay, although the case here is advisable to be brought to the corporate tribunal because of the benefits that normally being what do you call it, enjoyed, yeah, by the interested person. This particular issue, any particular issues in corporate tribunal also can be brought to or be referred to the High Court. Yeah, this is clearly stated under Section 30A, subsection 1, whereby normally the High Court shall confirm, vary, substitute, or quash the decision or make such other order. So meaning that the decision of corporate tribunal is not final. It can be referred, yeah, to the High Court, right? So the next slide. Okay, just to share with you what is the difference between the system that we have in Malaysia and corporate tribunal in Australia. It has been in Australia for so long. I just pick this country because they have they have a very good system of corporate tribunal in their country. The difference between the first one, the difference between Malaysia and Australia corporate tribunal is in Australia, it is done by autonomous entity governed by Australia's federal court. So it is like a court, but perhaps in a simpler version. But in Malaysia, we have nothing to do with courts, except for if there is an appeal, it can be brought into to be referred to the court of law. Yeah, and the law and regulations, it is also, as in Malaysia, created under Corporate Act 1968, and also they have corporate tribunal procedure. The same goes to Malaysia, and this tribunal structure is totally different from Malaysia. They have president and deputy presidents and other governor general named members. So they are actually coming from the Australia's federal court, meaning that they are also judges. Yeah, for deputy president must be a district court judge or a state of territory supreme court, and this does not apply to Malaysia. Malaysia, coming from, as I mentioned, is a government servant. Yeah, and the power statutory, there are two power given. Yeah, one is through statutory licenses. Yeah, they permit reproduction of certain copyright materials by educational institutions assisting person with certain disability. So this is the power given to the corporate tribunal in Australia. And also there are also voluntary license matters, dealt by the corporate tribunal in Australia. So the result of negotiation between a copyright owner or its representative, such as a collecting society and the licensee. So this is something that is voluntary. It is between, if anything happened, because of the perhaps dissatisfaction, between based on the agreement between the CMO and perhaps the singers or musicians, they can actually bring this case to the corporate tribunal in Malaysia. This is actually like what we have in Malaysia. Okay, I think the last slides that I have. As a conclusion, recent conflicts demands the effective roles by the copyright tribunal. Although, as I mentioned just now, the Malaysian Copyright Tribunal differs from one in the Australia, which consists of judges of the judiciary system. The power given for Malaysian tribunal members is clear, as being mandated in Section 28 of the Copyright Act 1987. With the new amendment of placing issue of royalty payment under the ambit of corporate tribunal, it is foreseen that the tribunal will be busy receiving numbers of cases to be considered, determined, and enforced upon. It is a hope that the new line of tribunal members is which is yet to observe and explore cases under its jurisdiction, once decided, would set a new paradigm, which expected to give impact to the corporate society in Malaysia. So I think with that, I end my presentation. Thank you very much.
Once again, please clap your hands, audience. It's very impressive that we learned about the copyright tribunal in Malaysia. I personally impressed with the news displayed by Ms. Nazura about Datuk Sheila Majid. It's idol to many Indonesians, I think, including me. Also, the comparison with the same similar tribunal in Australia. I think we can learn a lot from the presentations. And I remind the participants and viewers of this conference, if you have any questions, please do not hesitate to write on the chat bar or something like that. The last presenter is Mr. Ade Maman Suherman, Professor Ade Maman Suherman. I will read a brief biography or curriculum vitae of him. Mr. Ade Maman Suherman was born in Kuningan, West Java, 11th of July 1967. He graduated from this law faculty in 1990 and obtained his master degree in University of Groningen in the Netherlands. And Mr. Maman, Ade Maman finished its doctorate degree in Faculty of Law, University of Indonesia, and is now currently our Dean. Mr. Maman will be presenting his paper entitled Global Governance and Justice of the World Trade System. We have like 30 minutes for you, Mr. Maman, to present your paper. The time is yours. Thank you.
Okay. Assalamualaikum warahmatullahi wabarakatuh. Thank you to the moderator, Mr. Manunggal. Before starting my presentation, I would like to send my warm regards to the previous speaker, Prof. Thomas in Yogyakarta, and also the Honorable Professor Nazura, the Dean Faculty of Law, Fakulti Undang-Undang, University Kebangsaan Malaysia. Thank you for your contribution to this forum. And now I would like to come to my turn today. Today I would like to present my paper here that's entitled Global Governance and Justice of the World Trade System from Indonesian perspective. Okay, could you share the presentation from the technician, please? Okay. Today I would like to present this issue about the global governance, justice, and also related to World Trade System. Today is all the regulation, all the policies in a particular country, in all states as well, always connected with global condition and global demands as well, and also all the regulation and best practices developed by international organization and other institutions that cover all over the world. Ladies and gentlemen, first I would like to highlight that today, first slide. This is about state in global society and also about justice. Okay, the state regulates all its citizens with large population and legitimate government to regulate various small and the private and public domains. So, both in terms of internal and external sovereignty, of course, yes. And state interacts with international organization and institution. So, if we talk about global governance and also about justice and about trading system, so we have to discuss about the development of international law concerning trade and also how to interact each other between one state and another state. Okay, and then also states do not exist in vacuum. It means that no state in the world can exist without the influence of other states. So it's already happened that between state and among nations also always have a kind of interdependency each other. So there are other powerful agents as well in the world, such as other states, multinational corporations, and also international public institutions, and also such potential dominators in relation to one's own state. Okay, ladies and gentlemen, the audience, every domestic problem always has aspects of globalism, which are always related to entities outside the state. Okay, that's the truth. I think that all things happen in certain country, always related to the influence or the effect from other state. Yeah. Okay. There are four mega trends currently in the world. First, that a greater share of the global economy, more accessible technologies, particularly in communication, breakthroughs in global cooperation in tackling basic human needs, and also the evolution of complex sets of problems in spite of the progress. So the problem always comes every day, and also how to overcome the dispute or the conflict between parties or between a state or between entities or organizations. Here also developing countries in the context of global society that possess large composition in the population and region. Yes, we know, all the people know that developing countries, mostly all developing countries have great share to the number of population in the world in global society. And the welfare and justice has not yet reached as in developing countries have. So it's quite ironically that the number of population is located in mostly in developing countries, but the welfare level or the development level as in the lowest one. The facts show that increasingly inequality and also injustice between one state with another country, and also even in interregional and one another. Okay, ladies and gentlemen, the next issue, I think we have to discuss this issue, how to relate between law, governance, and social justice. In this paper, I would like to highlight again about how to insert global justice and global governance. So today's society always discuss in side by side, means that global, external, and also international aspects always has influence to the internal affairs of certain states. So global governance also contributes how to design the global justice, and also the system of how to empower, how to implement the law and regulation and governance in its states. And also the next one, how is the role of international organization in the context of global governance in addressing inequality and injustice? So it's big questions that in fact that in the world there's kind of a gap between the poor and the rich. So there's kind of inequality. There's also injustice comes out from there. And how but Indonesia is facing global demands along with various international provisions, especially in the field of trade. Okay, ladies and gentlemen, and the next one, I think WTO provisions have an impact on the legal developments and also change in Indonesia by presenting cases submitted to the WTO for Indonesia, both as applicant or as a respondent state. Okay, ladies and gentlemen and all the audience, the following scholars elaborate the relation between justice and global welfare, justice and humanitarian aid and democracy, and global structure in international community. Okay, I know that this topic is quite theoretically because we have to discuss about the concept of justice and also the concept of global governance and also the concept of social justice itself. So I would like to present here some scholars that discuss about justice, the concept of justice. So here, the scholars, I will present here that the institution with global scope from moral cosmopolitanism and political practice, this is by Charles Jones, and also cosmopolitanism, democracy, and distributive justice, it's advocated by Simon Kenny. And also the next author, Institution for Global Justice by Nancy ICOLGAS, and Global Distributed Justice, Entitlement and Desert, Gillian Brooke, and also Global Distributed Justice, an egalitarian perspective by Cecil Fabre. So there's some books and reference if we want to learn more about justice, about distribution, about cosmopolitanism and distributive justice, and etc. The next, this one author from Nagel. Nagel says that there's the difference between duty of humanity and the duty of justice. So here we notice that there are two terms that we have to differentiate between the concept of duty of humanity and the duty of justice. So it's quite important, I think, how to insert this issue, this term to legal or to regulation or to government policy in international or in national level. So it's quite interesting that the duty of humanity and the duty of justice. And also Nagel argues that the eradication of extreme global poverty is required by a duty of humanity, but not justice obligation. So it's interesting enough that duty of humanity, but not as justice obligation. The state must fulfill both duties into both imperfect and perfect duties. So there's two kinds of duties here. There are perfect and imperfect duties. Okay. And also for adherents who believe in this distinction, the fulfillment of obligation includes the category of duties that are imperfect one. So that's all about the concept and also the view from Nagel about humanity, about the duty of humanity and also the duty of justice. So here next about domestic institutions should ensure fair terms to cooperation among persons. International institutions as well ensure the fair term for cooperation between societies, people, and also he calls them it's responsible for the well-being of its individual citizens. Persons do not cooperate with one another sufficiently to consider justice to be the property of international institutions that mediate relation between persons. So it's quite important the last point here about justice. Yes, justice should be considered as the property of international institutions. Okay, the next author about justice advocated by John Rawls is very famous author concerning the concept of justice. Yeah. According to John Rawls, that justice employed for the domestic case and international case are structurally different. So it's totally different if you talk about domestic affair, domestic case, and also international case or international affair. From international original position, this is the concept from Rawls, that there are at least 8 principles should be applied to achieve or to make justice come to reality. Here, the law of people would be affirmed by parties. Respect for sovereignty, yes. And also the relation among states should be non-intervention, self-defense, respect for minimal set of human rights, and also duty of assistance to a burdened society, but not principle of egalitarian distributive justice. So the main point here from Rawls that we can note that we have to give the assistance to burdened society. So mostly in the world, the burdened society can be classified and can we name that from mostly developing countries, because the huge debt and also every year developing countries have huge debt to international financial organization. Ladies and gentlemen, the next slides we need to elaborate about understanding the relationship between global rich and the global poor. So it's the fact that in national condition or in international condition, the fact that society in the world always there are the global one, the rich one, and also the poor one, which is associated with humanitarian assistance for the global poor, is confronted with the concept of, this is the key point here, whether it is a matter of charity rather than obligation. So this is quite abstract concept, considering regarding how to differentiate between matter of charity rather than of obligation. So it's two terms is totally different and has different consequences in legal terms. Moral demanding of you according to which were responsible for the suffering. Okay. Ladies and gentlemen, for the next slides, here I show you the international organization, state, multinational corporation. Next, okay. The slide that has some pictures. International organization, state, multinational corporation. That's the title. Can you show this slide? C point C. International organization, state, multinational corporation. Okay. Not yet. Oh, I think it's to pass the. Okay. Okay. International organization. I show you here there are 3 pictures from World Trade Organization and also World International Property International Property Organization, and also the map of developed countries in the world. Yeah, this is the picture that I show you. That this is the World Trade Organization, the institution that regulates all the behavior of state, how to treat between state or among state each other. And also the World Intellectual Property Organization. This is an organization that designed by United Nations as well to regulate and to protect the property rights in all member states, including Indonesia as well. So I noticed that Indonesia has a lot of cases in property rights case and dispute between parties, and also Indonesia as applicant or respondent state. Okay, this is one thing. Next, please. Next, this is about the injustice. Yes, injustice. How come the injustice could happen in the world? Because here there are multinational corporations international organizations such as the World Trade Organization, World Bank, and the International Monetary Fund, and powerful states. So the last one, it's states, not organization. So organization plus the powerful states. The powerful means here economically, politically, military, and others, and so on. So they are, yes, multinational corporation, international organization, and powerful state enact rules and create institutions from which the global poor cannot realistically exit. Yes, so it's quite important this point. Globally, global poor cannot realistically exit. So the poor countries, the poor people in the world cannot exist from the system that already designed by the multinational corporation, by international organization, and also from the powerful states in the world. And also the next one, the obligation toward the global poor are obligation of justice rather than the charity. So we agree that we have to emphasize and to highlight that global poor need humanity or assistance for the other people from wealthy nation. It is as an obligation of justice rather than the charity. But I think it should have kind of concept that we have to help other state that less disadvantaged. Yes. So we have to obligation of justice rather than charity, because charity is imperfect right. Yes, imperfect rights that cannot enforce. Yes, ladies and gentlemen, and the audience, and next, I think this is about the WTO has created the international trade relation. That here clear that benefiting large multinational companies to the disadvantage of local industry and firms. Small and medium enterprises are responsible for the largest share of employment opportunities in the most countries. Trade obstacles such as tariffs, costly border procedures, and also other non-tariff barriers place a larger burden on small and medium enterprises than bigger multinational firms. So here I would like to highlight again that a small medium enterprise compared to big multinational corporation has a totally different access and different chance and opportunity to access justice, and also to access to proceed to have kind of property rights claim. Yes, the property rights regime is more comfortable for the multinational corporation than small medium enterprise, because there are many obstacles, and also small medium enterprise is very limited resources, human resources, and also the capital resources, and then financial resources. Everything is limited for the small medium enterprise. So it's quite difficult to afford or to have kind of claim for a right, the property rights, such as a brand or patent or industrial design, and etc. And also multinational companies have been able to tap into market in poor countries. Yes, clear, yeah. These multinational companies have been able to tap into market in poor countries, and even secure patent right to natural resources pay for multinationals. Okay, ladies and gentlemen, once more from Simon Kane that he argues that there are not strong grounds to suppose that revised statism would be any less efficient than Wood's cosmopolitan democracy in securing the goals of global justice. So it's kind of the concept that we have to encourage the state to make more regulation to create justice in their countries. Yeah. So this statism means that all policy or regulation that should be referred to any countries or state, yes. And then cosmopolitan democracy is strongly related to a global system and global governance and global institution, how to create global justice in global society. And the next one, the next concept is about moral cosmopolitanism. This is about moral cosmopolitanism is universal, yes, in its scope, and so the very less it rules out inequalities in basic interest protection for the individual. So, if any human being is entitled to protection of her basic interest, every human being is likewise entitled. This is the first premise, yeah. And then the second premise, on the basis of these two premises, yes, the moral cosmopolitans should support core justice promoting social, political, economic institution with global scope. So from global perspective, yes, cosmopolitans concept. So the structure, the system should support, yeah, core justice and promoting social, political, and economic institution with global scope, not only in certain state. So this concept designed to structure in global community, in global institution. And the next, still two author, yes, that already mentioned here, still have to mention from the POG moral cosmopolitan belief that world poverty and human rights, yes, each individual person is fundamental unit of moral concern, and that each person counts equally from the moral points of view, so that neither sex, nor class, nor nationality, nor citizenship, nor religious affiliation, nor any other distinguishing feature of person can alter the basic moral equality of individuals. So it's quite clear this concept, I think, is very strong related with the concept of international human rights, because the human rights says that international human rights says that all human beings born equal in dignity. So without how to discriminate the people or the human being based on gender, sex, also class or nationality or citizenship or religious belief system, and etc. So the central idea of moral and cosmopolitanism is every human being has a global stature as a ultimate unit of moral concern. Okay, there's I think about the concept justice, about statism and cosmopolitanism. Already mentioned and already explained, and I think it's the last concept I would like to show you from Wiener, yes. So it's about legitimacy is weaker standard than justice. So it's new things, important thing as well, that all legal scholars always talk about legitimacy, but according to him, to Wiener, that legitimacy is a weaker concept, a weaker standard than justice. So justice is stronger. Yes. Justice is stronger than legitimacy. So justice is more important than legitimacy. So it's, I think it's very theoretical and very philosophically, I think, interesting to discuss about legitimacy and also about justice. According to him, legitimacy is a weaker standard than justice. So justice is very, very important. And then the problem of legitimacy is the focus of roles that are work. This the problem of justice characterizes the core of this work. Yes, it's about the concept of John Rawls concerning justice. Okay? That legitimacy is, again here, legitimacy is a primitive concept. It's quite interesting. Legitimacy is primitive concept of normative recognition. So it's something primitive. This legitimacy is primitive one, yeah, from the normative recognition. So a legitimate regime imposes duty on its citizens instead of merely issuing command and them. So when we recognize a government and we recognize it as a government instead of merely a powerful gang. Okay, ladies and gentlemen, this is the next that nearly over about global governance and international organization. So global governance through international organization is the only effective choice. Yes, I believe that, I'm sure that global governance should need international organization, and also governance which should be based on the principle of justice. An international organization as an agent, and the state must reflect in the interest of the state. Okay, and then the next one for the agency theory. Please show the slide. The agency theory applied that international organization implies that certain states, the principles, state as the principal, set up an international organization as the agent to perform certain function that will benefit the members. So the member will set certain goals for the international organization to accomplish. So it's quite clear that it should the same and all the same interest and also strong relation between principles and agency. It's quite theoretically, I think, about state international organization. So it's kind of agency theory. We call it agency theory. Yeah. So international organization as agent should perform on behalf of the state, right? So I think it's the next is about the term that if the agent doesn't reflect the state interest, we call it agency losses or costs incurred by agencies like. Okay, okay, ladies and gentlemen, all the audience, all the participants of this conference, we come to the last part of this presentation, and also I think time is nearly over. Yes, Mr. Moderator. I would like to sum my presentation here. Please show the Indonesia and WTO. This is kind of a brief conclusion on my perspective that here there's agency losses or costs incurred by agencies like this is kind between Indonesia and WTO. It's kind of agency losses or costs incurred by agencies like because of the interest of Indonesia as a state still not related nor it doesn't reflect the interest of Indonesia because the people of Indonesian people still want to fair trade, more justice rather than the certainty, and also about how to apply all the WTO provision. Yes, and also fair or unfair trade. We know that we need not only free trade, but we need fair and fair trade and justice. So it's quite interesting between fair and unfair. Yeah, and legal fee. Yeah, I would like highlight here that legal fee and unportable costs, because the system designed by international organizations such as WTO, how to sue the certain state before WTO dispute settlement body, it need huge cost, big money, and also it's really unaffordable for developing countries how to have a justice from them, from this institution. Yeah, and also as a respondentship, Indonesia, according to my notes in my paper, my full article, I elaborate that Indonesia mostly has become a respondent state. So it needs a lot of money as well to finance the legal fee, yes, and also how to handle the case in WTO system, and also big losses in WTO cases. And the last one I think is small medium enterprise has no good access to intellectual property rights regime. So I think it's undebatable. The small medium enterprise has no good access to gain the international the intellectual property rights claim, because it's still quite expensive, I think, in Indonesia. But if this design according to it's paid by US dollar, not in Indonesian rupiah, maybe it's quite cheap, I think, for developed countries. But for developing countries, it's quite big obstacle, I think, and difficulties. And then the lack of non-economic consideration related to environmental protection. So environmental protection something crucial in developing countries, because mostly in developing countries suffer from deforestation and also unmanageable unmanageable project. Yes, from the environmental perspective, it's still a lot of problem. Yes, and also the consequences of environmental deprivation, the prevention are likely to harm the global poor the most, which in turn will deepen and dependence on affluence as well. So that's all my presentation. I think that I will sum again. I will conclude again that I discuss a lot about the concept of justice and also the concept of injustice and global governance, and also I try to relate this concept to social justice, and then I relate to global governance that involve the international organization, multinational corporation, as well as over there the most powerful states also have a big share, I think, and big, mostly a developed country interest over there in global system. So here, all the audience, all the participants can judge by your own judgment how the global governance would be look like in the next time, particularly in the pandemic time. So I think from this forum, I suggest that we need to reformulate, restructure the global architecture of the global governance in more justice, and also can contribute to social welfare and also economic growth, and can eradicate the poverty in the world, and to reduce the gap between the poor and the rich nation. I think that's all my presentation. Thank you.
Impressive, Mr. Ademaman. Thank you for the presentation. Ladies and gentlemen, we will be proceed to question and answer actually, but we still have around 10 or 12 minutes left. There are questions that came into our desk. The first is for Professor Thomas. Professor Thomas, there is a question for you. Actually, some questions from Risang Fatumal. In democratic countries which value freedom and individual rights, that's also guaranteed by the Constitution, do you think it is still in line with the value to hold the general elections that maybe few communities think it is not supposed to be the main agenda in this pandemic situation? I think it is also an issue now in Indonesia, whether we have to...
Sorry, can you please repeat? I did not understand.
Okay, a question for you. In democratic countries which value freedom and individual rights, that guaranteed by the Constitution, do you think it is still relevant or in line with the situation right now to keep on holding general election? Like we have now, we are facing local government election or pilkada. What do you think? Is it still important to hold general election or not? And then another question for you, Mr. Thomas, is what, considering that you are in Indonesia now, in your observation, what do you think, is there any difference the handling of COVID-19 in Indonesia based on your observation, and in European countries, especially maybe in Germany, yeah? That's the two questions for you. And we have also another question for Ms. Nazura. Ms. Nazura, the first question for you is, are there any differences in the law cases, examples, which the parties prefer tribunal instead of court? Yeah, so are there any differences in the law case examples which the parties prefer tribunal instead of court? This is a question from our student Waode Isa. Another question, wait a second. Yeah, I think that's all that we have now. Mr. Thomas, you can answer maybe for 1 or 2 minutes for a question. Thank you.
Yes, thank you very much. So interesting questions. Were not so easy to answer. Is it still okay to hold general elections under the conditions of the COVID-19 pandemic? The abstract answer is it is still okay as long as the electoral campaigns of the candidates can still unfold. That means they can reach the citizens with the media and they can have events. I think personally, at the moment, it is still possible to have that with strict health protocols. So what I would probably require myself, this is my opinion, is very strict rules which are supervised by the government that any electoral campaign events, demonstrations, meetings, and so on follow strict health protocols, in particular ensuring the physical distancing, what we call social distancing. What happened in the United States, where they found out yesterday that the Trump events of people gathering without masks probably have caused more than 700 deaths. I think that is not okay. But it is possible to overcome such problems. Second question, difference in handling COVID-19 and in Europe and Indonesia, that depends very much on the individual European country. Some countries, like for example France, which had been affected very strongly, or Germany, they are very strict. The measures they have taken were a little bit more strict than in Indonesia, but we need to take into consideration that the problem of COVID-19 is much more severe in the cold European countries than in the tropical country Indonesia. What I would say is the main difference is that there is more discipline enforcing the regulations. For example, I have heard that in Yogyakarta there is the regulation that people are obliged to wear a face mask in the public. But at least 30% of the people simply don't do. And in some countries, like in parts of Germany, we have very strict controls. So, for example, the police is really stopping, and they may stop in a city like Yogyakarta on the weekend, maybe several thousand people, and give fines to them, so that they really enforce the rules. I think the biggest difference in Indonesia is always that the regulations do have little practical effect because they are not effectively enforced. But that is the main difference. Thank you.
Thomas for the answers. Now we proceed to Ms. Nazura to answer the questions. Ms. Nazura, are you with us?
Yes, yes.
Yeah.
I'm here. Can you hear me?
Yeah.
All right. Okay. Thank you for the questions. Yeah. Right. I think I have mentioned in my presentation that there are differences between the case brought up to the court of law and tribunal. Yeah, it is more of the difference in terms of the cost, the time, the process, and also the experts. Yeah, involved. Yeah, in the matters brought about to both system. Yeah, either it is a court or a tribunal. Yeah. That is the main differences. Yeah, but in terms of the question is more of like wanted me to answer whether there are cases reported, yeah, which I can actually share with you the differences between those two. Unfortunately, until now, the tribunal has not been what do you call it? Has not been tried any copyright cases yet. Yeah, I think I have not mentioned clearly in my presentation just now. The copyright tribunal in Malaysia has been there since 2003, but because of certain things, it has not been. I can say that it has not been used properly by the committee. So then, I think because of there are a lot of insufficient provisions in the law at that point of time. But then it was then being amended in 2012. But still, they at that point of time, the ministry has appointed the members of tribunal, the chairperson, and anybody that is necessary to set up or to establish the tribunal. Yeah, but still, there are not many cases brought about because of certain issues. The interested person or interested parties, like the collective management organization, or perhaps the people in entertainment industry, they would like to bring the case straight up to the minister, rather than to bring it up to the tribunal. Because of that, then they look up again what is actually happened. Why didn't people come and share with the tribunal their problems? Then again in 2020, we amended the law so that it becomes more friendly to the entertainment industry, particularly. Even though when you look at the jurisdiction, it's not necessarily only for entertainment industry. It can be for content creative industry as well. I think that is among the reason. I cannot answer really. Exactly the questions that you asked, because there are no cases yet being brought. But that was the reason why. I hope that my answer, to a certain extent, satisfy you. Thank you very much.
There are still some questions, but I have to be strict with the time. I have 1 minute left actually, so I need to end the session. There is no conclusion that I make, I think, but we all have learned from the 3 invited speakers, from the legal philosophy, developments of law, and many more aspects on law in global relation, and from how to coping with the pandemic, COVID-19, and the copyright issues. I'm giving the time and place to the Master of Ceremonies. Thank you so very much.
Okay, thank you, Mr. Manunggal, who has led this session, and all of the speakers.
And now we will give online certificates for, first, Professor Dr. Thomas Smith, DAAD Lecturer at Universitas Gadjah Mada and Adjunct Professor at the University of Göttingen, Germany.
Terima kasih.
Thank you very much.
And second, for Professor Dr. Nazura Abdul Manap from University Kebangsaan Malaysia.
Thank you very much.
Terima kasih. Thank you very much.
You are welcome. You are welcome. And now, for the third speaker, we will get placard will be delivered by Chief Committee. Please welcome Dr. Teddy Sudrajat. And Professor Dr. Ade Maman Suharman, SH, MSc from Universitas Jenderal Sudirman. Thank you very much, Prof. Ade.
Thank you, ladies and gentlemen. The next agenda is a break time for 30 minutes to have a special virtual tour of Purwokerto. You're welcome to enjoy the video that we have prepared, and we'll be back at 1 p.m. So here we go.
Please enjoy.
Tidak banyak yang tahu tentang tempat ini. Tempat yang membuatku tenang. Tempatku mendapatkan inspirasi. Mungkin tidak banyak yang menjadikan tempat ini spesial. Tidak banyak kemewahan di sini. Tapi di sini aku mendapatkan pelajaran bahwa kesederhanaan, kebersamaan dan keramahan adalah kemewahan sejati yang mungkin bagi banyak orang sulit dicari. Inilah yang membuat tempat ini begitu spesial bagiku, yang kemudian membuatku jatuh cinta. Aku tak menyangka bahwa tempat ini akan membuatku jatuh cinta. Sebuah tempat kecil yang sederhana, yang memiliki sejarah dan keunikannya sendiri. Di sini budaya terjaga dengan asli, dilestarikan dengan segenap hati, bertransformasi dan berjalan bersama dengan kemajuan. Di sini kemewahan justru berasal dari kesederhanaan. Dan ketenangan bisa aku dapatkan dari kebersamaan. Banyak sekali surga-surga kecil yang tersembunyi di sini. Bukan hanya alamnya yang asri, ataupun warisan budaya yang lestari, namun juga nilai-nilai luhur yang tertanam di setiap individunya, kenikmatan di setiap sisi perjumpaanku, menciptakan cita rasa yang khas, membuatku selalu ingin kembali. Banyumas, bagiku bukan hanya tempat saja. Namun juga kearifan yang ada di dalamnya, yang ada di setiap orang-orangnya yang ramah dan bersahabat, ada di setiap sisi sentuhannya, dan di semua sudut lingkungannya. Banyumas bagiku bukanlah tempat di mana aku bisa menemukan banyak kemewahan, tapi Banyumas adalah tempat aku bisa menemukan ketenangan dan inspirasi. Tempat di mana aku bisa menemukan surga kecil yang tersembunyi.
Kebun Raya Baturaden merupakan destinasi wisata pendidikan lingkungan yang strategis. Terletak di Jawa Tengah bagian tengah, kurang lebih 14 km dari Purwokerto. Tiket masuk murah, hanya 3.500. Kebun Raya Baturaden mempunyai 7 taman tematik, 9 taman taksonomi. Inilah Kebun Raya Baturaden, Kebun Raya Baturaden milik kita.
Aku selalu ingin kembali ke sini, di taman ini, di kolam ini. Dengan pemandangan yang indah saat matahari tenggelam. Tempat yang membuatku rindu, di sini, di Taman Balai Kemambang.
Setelah berbagai fasilitas, sarana, dan prasarana selama pandemi,
akhirnya dilakukan simulasi pembukaan lokal wisata Baturaden dengan penerapan protokol COVID-19. Hai, namaku Eka Risma. Kali ini aku bersama temanku Devi mendapat kesempatan untuk mengikuti simulasi. Selama berwisata, kita harus tetap memperhatikan physical distancing. Petugas objek wisata juga menghimbau kami untuk tetap selalu menjaga jarak.
ada petugas yang mengecek suhu tubuh kami.
Kami juga mendapatkan stempel sebagai tanda bahwa suhu tubuh kami normal dan boleh masuk.
Terdapat tempat cuci tangan di sebelah loket pembayaran dan di dalam objek wisata.
Kami membayar tiket menggunakan kartu Brizi. Nah, di sini juga disediakan top up saldo untuk kartu Brizi.
Selama berkeliling, kami melihat banyak himbauan untuk berjaga jarak.
Kami merasa kelelahan dan kami pun duduk di kursi dengan pembatasan jarak.
Aku melihat penjual makanan khas yaitu pecel dan mendoan Baturaden. Mereka juga melaksanakan protokol COVID-19 loh dengan menjaga jarak dan kebersihan.
Akhirnya, kami sempatkan untuk makan dengan tetap menjaga jarak. Jangan lupa buang sampah pada tempatnya. Jangan lupa ya untuk tetap mengikuti protokol COVID-19. Sampai jumpa di lain waktu.
Siki pemerintah wis agi mulai nerapna new normal ya. New normal siapa Nur? New normal ya kae lah. Normal baru sing wis diterapna nang segala hal. Contohnya ya, Siki wis wajib nganggo masker nang di papan, sering wisu, aja kepelekan karo wong liya. Siki pemerintah wis pada siap-siap menjalani new normal. Ki malah museum wayang Banyumas wis gawe SOP nang pengunjung sing pada tak maring museum. Berarti nek mari ngono kudu nglakoni SOP new normal ya Nur. Ya iya kok, demi keselamatan kabeh sih.
Mari berkunjung dan ikuti petualangan wisata sejarah dan religi dari Kabupaten Banyumas yang menawarkan pengalaman baru.
Tidak banyak yang tahu tentang tempat ini. Tempat yang membuatku tenang. Tempatku mendapatkan inspirasi. Mungkin tidak banyak yang menjadikan tempat ini spesial. Tidak banyak kemewahan di sini. Tapi di sini aku mendapatkan pelajaran bahwa kesederhanaan, kebersamaan dan keramahan adalah kemewahan sejati yang mungkin bagi banyak orang sulit dicari. Inilah yang membuat tempat ini begitu spesial bagiku, yang kemudian membuatku jatuh cinta. Aku tak menyangka bahwa tempat ini akan membuatku jatuh cinta. Sebuah tempat kecil yang sederhana, yang memiliki sejarah dan keunikannya sendiri. Di sini budaya terjaga dengan asli, dilestarikan dengan segenap hati, bertransformasi dan berjalan bersama dengan kemajuan. Di sini kemewahan justru berasal dari kesederhanaan. Dan ketenangan bisa kudapatkan dari kebersamaan. Banyak sekali surga-surga kecil yang tersembunyi di sini. Bukan hanya alamnya yang asri, ataupun warisan budaya yang lestari, namun juga nilai-nilai luhur yang tertanam di setiap individunya, kenikmatan di setiap sisi perjumpaanku, menciptakan cita rasa yang khas, membuatku selalu ingin kembali. Banyumas bagiku bukan hanya tempat saja, namun juga kearifan yang ada di dalamnya, yang ada di setiap orang-orangnya yang ramah dan bersahabat, ada di setiap sisi sentuhannya, dan di semua sudut lingkungannya. Banyumas bagiku bukanlah tempat di mana aku bisa menemukan banyak kemewahan, tapi Banyumas adalah tempat aku bisa menemukan ketenangan dan inspirasi. Tempat di mana aku bisa menemukan surga kecil yang tersembunyi.
Raden merupakan destinasi wisata pendidikan lingkungan yang strategis. Terletak di Jawa Tengah bagian tengah, kurang lebih 14 km dari Purwokerto. Tiket masuk murah, hanya 3.500. Kebun Raya Batu Raden mempunyai 7 taman tematik, 9 taman taksonomi. Kunjungilah Kebun Raya Batu Raden, Kebun Raya Batu Raden milik kita.
Aku selalu ingin kembali ke sini, di taman ini, di kolam ini. Dengan pemandangan yang indah saat matahari tenggelam. Tempat yang membuatku rindu, di sini, di Taman Balai Kemambang.
After having lunch and pray, let's start the plenary session 2. It will be delivered by our speakers. First, Assistant Professor Osaid Awauda, LLB, LLM, PhD from Hebron University, Palestine. Second, Profesor Dr. Igusti Ayu Ketut Rahmi Handayani, SHMM, from Universitas 11 Maret. And third, Profesor Tri Lisiani Prihatina, SHMA, PhD, from Universitas Jenderal Sudirman. And this session will be guided by Ms. Ulil Ahwa, SHMH, as the moderator. Now we will read her curriculum vitae.
Mrs. Ulil Ahwa, SHMH, was born at Purwokerto, 25th September 1987. Her education background: first, Faculty of Law at 2009 at Universitas Jenderal Sudirman. Second, Master of Law Study Program on 2014 at Universitas Gadjah Mada. And her academic experience: first, lecturer at Faculty of Law Universitas Jenderal Sudirman from 2015 until now. Second, Secretary at International Undergraduate Program, Faculty of Law Universitas Jenderal Sudirman. Her courses taught: undergraduate, first, research methods and legal writing. Second, corporate law. Third, commercial law, sociology of law, legal anthropology, and law of demography.
And now we invite Ms. Ulil Ahwa. Ms. Ulil Ahwa, time is yours.
Thank you very much for the master of the ceremony to giving me time. Assalamualaikum warahmatullahi wabarakatuh. Welcome back everyone, and thank you to keep your active engagement with us in this conference up until this afternoon. This is the second plenary for today, and if the previous plenary talks was explored on various issues related to the legal philosophy, governance, business law, international and private law, in this session we would like to explore more on the discussion in the topic of constitutional law and issues related to the social justice. Join with us today 3 bright and well-known speakers, and it is my utter delight and privilege to welcome. The first, we have Assistant Professor Osaid Awauda, PhD, from Hebron University, Palestine. Assalamualaikum, Mr. Osaid, have you joined us?
Alaikum salam wa rahmatullahi wa barakatuh. Thank you so much for this wonderful introduction. It's my pleasure to be with you all.
Good afternoon from Indonesia. Yes, maybe this is still morning in Palestine. How are you doing?
That's right. Well, very well, thank you. I hope you're all well.
Thank you. Okay, next. The next speaker, we have Professor Dr. Igusti Ayu Ketutrahmi Handayani SH, MH from Universitas 11 Maret, Indonesia. Good afternoon, Prof. Ayu. Have you joined us today?
Thank you for this invitation.
Okay, good afternoon, Prof. We are pleased to have you here. The next, join with me today, Professor Tri Lisyani Prihatina MA PhD from Faculty of Law Jenderal Sudirman University, Indonesia. We are pleased to have you here, Prof. Tri Lisyani SH, PhD.
Okay, Assalamualaikum warahmatullahi wabarakatuh.
All the speakers will have 30 minutes for the presentation, and Q&A will be conducted after all presenters finish their presentation. Okay, ladies and gentlemen, before we go to the first speaker, I would like to give brief introduction about our first speaker. We have Assistant Professor Osaid Awauda. He is an Assistant Professor of Constitutional Law at Hebron University, Palestine. He teaches public international law, research method, and introduction to juridical science. He holds an LLB from Birzeit University, an LLM and PhD from Melbourne Law School, Australia. His PhD thesis title was The Palestine Supreme Constitutional Court, and he has already participated in multiple conferences and published many papers discussing the legal challenge present in Palestine in various fields such as tax law, labor law, international humanitarian law, and judicial practice. Without further ado, please welcome our first speaker for the second plenary, Mr. Osaid Awauda. Time is yours.
Thank you so much, Ulil. I'll first start by sharing the screen because I have a PowerPoint that I would like to present to all of you. Give me 1 minute. Multiple participants can share. Okay. Now, how can I start sharing my screen? Okay, start screen. Oh, that's it. Thank you. I'll just make sure that I put it on the wider range. Yeah, that's it. Bismillah ar-Rahman ar-Rahim. Assalamu alaikum wa rahmatullahi wa barakatuh. Greetings of peace to all of you, organizers, participants. Professor Maman, thank you so much for granting me the opportunity to take part of this conference. The presentation that I will give today is about the Palestinian regime's violation of the right to property in the West Bank. I know that lots of people need a brief introduction about the legal system here in Palestine, and this is what I will start with. This presentation, as mentioned in the title, discusses how the Palestinian regime violated the constitutional right to property in a case called Rawabi case. I'll give further information during the presentation of each slide. First of all, just trying to get a brief understanding of what is the legal system is like here in Palestine. First, Palestine is separated now into three territories. The West Bank and Gaza Strip, that is under the limited control or limited governance of the Palestinian Authority, and the rest of Palestine that was occupied by the Israeli occupation forces in 1948. That was after the British mandate that was put on Palestine from 1917 to 1948. So that was the first phase, the phase of the British colonization of Palestine from 1917 to 1948. At that time, Palestine was part of the Ottoman Empire. It was followed by the Zionist Israeli occupation of almost all of the area of Palestine, except for the West Bank and Gaza Strip. That is in 1948. Since then, from 1948 to 1967, the the West Bank was governed by the Jordanian government, and Gaza Strip was governed by the Egyptian government. That is from 1948 to 1967. Then the Israeli occupation extended its the area that it occupied, and it also occupied the West Bank and Gaza Strip. So from 1967 until the signing of Oslo Accords in 1994, all of Palestine, especially the West Bank and Gaza Strip, was under the military administration of the Israeli occupation forces. In 1994, the Palestinian Liberation Organization, PLO, signed Oslo Accords, presented by Yasser Arafat, with the Israeli government. The Oslo Accords gave the Palestinian government a limited control over a limited area of the West Bank and Gaza Strip. West Bank especially was divided into 3 categories, A, B, and C. Area A, the Palestinian government has full control over its security and administration, and that constitutes only maybe 28% of the West Bank. The rest of the West Bank was classified or categorized as Area B and C. Both areas B and C were under the control of the Israeli forces, despite that they were parts of the West Bank. So we had our first government and our first parliament in 1996. The second election, parliamentary elections, took place in 2006. In 2006, something different happened. For the first time in an election, that is the participation of the Islamic Party of Hamas in the Palestinian election. At that time, the Palestinian resistance movement, Hamas, won 74 seats of the parliament. That is 74 out of 132 seats, which means that they have won more than 2/3 of the parliament. And winning more than 2/3 of the parliament allows a party to change the basic law of Palestine, since we do not have a constitution, to change the basic law of Palestine and enact or annul any law that that party wants. The Fatah party, the secular party, and other supporting parties realized that this major win by Hamas would make a significant threat to their interests and to their goals in the West Bank, especially the collaboration that they have shown with the Israeli forces against any kind of serious resistant movement that was taking place in Palestine. The situation remained intense and unstable from January 2006, the month in which Hamas won 74 seats of the parliament out of 132. It remained intense until the civil war started in July 2007. In July 2007, the Hamas military forces and Fatah military forces started fighting in Gaza Strip. Hamas party saw itself, and it was the legitimate enacted party of the Palestinian government, while Fatah party did not want to handle or hand over the control of the security apparatus in Gaza Strip to the newly elected government of Hamas. The civil war had its impact on the West Bank itself. Yes, it started in Gaza Strip, but it extended to the West Bank. And in the West Bank, the Palestinian president took 4 decisions. The first, he suspended the parliament, which is unconstitutional. The second, he declared the state of emergency. The third is that he declared Hamas to be an unlawful party, an unlawful movement that is going against the basic values of the Palestinian people. The fourth is that he started enacting decrees by law, in which he first resigned the government of Hamas, the new elected government of Hamas, and appointed a new type of government that is called emergency government. Until now, since 2007, until this day, that is 3rd of November 2020, we are governed by the state of emergency. The Palestinian president issues decrees by law under Article 43 of the Constitution, the basic law, which gives him the right to issue decrees by law that has the power of law when the parliament is not in session. We might go through this if we have some more time, but the main issue now is that the main issue to highlight here is that Palestine has been under a regime of emergency, under the state of emergency, since 2007. Surprisingly, in 2016, April 2016, the Palestinian president decided to establish a new constitutional court. While establishing that constitutional court, he decided to appoint all of its members single-handedly, without the effective participation of all of the other parts of the other organs of the state. And I believe that you can imagine how a constitutional court would operate. It definitely would not have any kind of independence or considerable ability to disagree with what the president says or what the president wants, in fact. So two things to conclude here. First, Palestine has been under a regime of emergency since 2007, in which the president issues decrees by law that has the power of law. Second, that we started having a constitutional court since 2016, April 2016. All of its members were solely appointed by the Palestinian president. Now, someone might ask, why would a Palestinian president in an authoritarian regime that is under emergency establish a constitutional court? The response from the literature lists 5 functions that constitutional courts perform in authoritarian regimes. First, social control, controlling the society in a way that consolidates the authoritarian nature of the regime. Second, marginalizing opposition, attacking all of those who oppose or at least legitimize marginalizing all of the opposition, those who disagree with the elite and the president. And what I mean by elite, not the chosen ones, but I mean people who are considered the clique of the president. Third, maintaining elite cohesion. What is meant by maintaining elite cohesion? Making sure that whoever is around the president or has a significant role in the state organs is someone who is loyal to the president and to the authoritarian party. If someone is seen or considered unlawful or disloyal, he is immediately removed from the clique. Fourth, providing credible commitments in the economic sphere. And this is what I will focus on while talking about Rawabi case. That one of the functions of constitutional courts in authoritarian regimes is to make sure that all of the investors are safe and confident that the investments and their wealth would not be affected by the actions of the authoritarian regime. Fifth and last, delegation of controversial issues to the judiciary. If there is something controversial that the president wants to make a decision about, he transmits or he delegates this matter to the Constitutional Court. And once the Constitutional Court gives the president the answer that he wants or that he likes, he applies what the court says, not telling the people that he is achieving his goal, but telling the people that he is simply being a court-abiding citizen, that he is just applying what the court said. Now, to give you a background about Rawabi case, Rawabi was the first man-made city in Palestine. And in order to start building the city, the president issued a decree by law in which he expropriated huge area of land from Palestinian farmers and then sold it to the company that was building Rawabi case, which is called Rawabi Investments, as I believe. So Rawabi Investments bought what the president had expropriated from Palestinian farmers. The president relied on the basic law of Article 43, an article that gives the president to issue decrees by law in times of emergency. What was the court's judgment? The court's judgment was is that this is a state of emergency. And what should be applied in a state of emergency is the president's right or the president's power to issue decrees by law in which no other state or organ of a state has control over. Now, this in fact was taken from a previous precedent of the court. So the court in Rawabi case relied on a previous precedent from the court. And that precedent was named Dahlan case. Dahlan case is one of the main, he is the main opponent of Mahmoud Abbas, the current Palestinian president. Now he resides in UAE and he is a counselor for regional security in the UAE. The court decided on Dahlan's case is that the president's decision to remove and lift parliamentary immunity from Dahlan, who was a parliament member, that was lawful. Lawful because the president has the power to issue decrees by law. Those decrees by law, if they are issued under the state of emergency, then they would be considered and deemed lawful and in accordance with what the basic law says. Now, it's important to note here that according to many jurists and constitutionalists, it is not open for the president to issue whatever decree by law he wants. Any decree by law he would like to issue must at least meet two criteria. First, it should be issued to face an imminent danger. Second, it should be issued to face an immense danger. So if the issue that the decree by law wants to regulate causes immense and imminent danger, then that decree by law would be deemed lawful and appropriate according to constitutional standards. But if the president is just issuing that decree by law for the sole purpose of satisfying his party's interests or his party's needs and fulfilling his own selfish party's goals, that is not a legitimate purpose to use the power of issuing decrees by law. Now, the court linked between Dahlan's case and Rawabi case. The court said in Rawabi case that according to what the court has established as a precedent in Dahlan's case, no one has the power to question or criticize the president's power to issue decrees by law. And whatever decrees by law he issues, that is deemed lawful and constitutional. Now, this is important because it is related to what is the court's law say in 2006. There are two different legal frameworks that regulate the work of the Constitutional Court. The Constitutional Court that in this specific case has served the interests of the regime. In which means? By providing the investors, Rawabi, a credible commitment that no one will be able to take the land back and that the investment is secured and protected in Palestine. When the president was questioned, when that decision was questioned by the president, by some of the constitutional lawyers, the court said that it is not for the jurisdiction of the court to discuss or to assess the decrees by law that the Palestinian president has issued. But in fact, this is not correct. According to the court's law, which is surprisingly different from the basic law, the court, yes, it has the power and it has the jurisdiction to oversee and review the presidential decrees, especially decrees by law that the Palestinian president issues. Now, this highlights a major issue or a major concern, or raises a major concern. There is inconsistency between the basic law and the court's law. In order to solve this inconsistency, it's important to go back to one of the basic principles of law, that is the hierarchy of legislation in a given state. It is well known that the basic law or the constitution rests at the top of that hierarchy, while in the middle comes laws that are enacted by the parliament. At the bottom of that hierarchy comes the bylaws and regulations that the executive authority issues in order to explain or give further details to legislation issued by the parliament. In this case, we have a contradiction between a law that is the court's law and the basic law. In this, it's important to say here that the basic law overrides the court's law. So yes, according to the basic law, the Palestinian president should not have issued that decree by law. And issuing that decree by law, expropriating the private land, is not for the purposes of meeting an immense and imminent danger, which means that the president's decision to expropriate that land is unconstitutional. But the court did not say that. The court simply said that it is up for the president to decide whenever he wants to exercise his discretionary power of using decrees by law without any criteria. Now, again, what does that mean? Why the court made that judgment? The Palestinian court, the Palestinian Constitutional Court, made that judgment in performing as a way of performing one of the functions of constitutional courts in authoritarian regimes. That is, providing credible commitments for investors in the economic sphere, giving the investors in Rawabi the credible commitment that their land, that the expropriated land would not be back or brought back to the people to its original owners. When may it change its practice? That is unknown. When would the court stop giving credible commitments to the economic sphere? This depends on when the authoritarian character of the Palestinian regime will cease to exist. And that can be hardly seen in the near future. Given all of the complex political events that are taking place currently around Palestine, especially with the normalization of the relationships between many Arab regimes and the Israeli occupation forces. And since there is no hope of receiving any kind of support from the EU, the UN, Russia, or the United States for starting a new election or holding new elections in Palestine. To conclude, why it's important to focus on such a question focus on such an issue? It is important because there is a wide belief that courts are guarantees, that courts can guarantee justice, and courts can provide people with fairness in its decisions. Well, that is not the case for courts in authoritarian regimes. Second, what can be done to reform the court? The only way to reform the court is to establish a new one. And to establish a new one, you need a newly elected parliament. And to get a newly elected parliament, you need international support. And given the current sphere, international support is very scarce and can hardly be expected from the main actors in the international community. What if reform is not possible? If reform is not possible, the only way is to keep fighting and keep exposing what the court is doing, in fact. And this is important because some of the authoritarian regimes try to build a facade of legitimacy over themselves by establishing courts. Now, the issue of exposing the faults and the frauds in many of the court's decisions would certainly help in showing how authoritarian and how unjust the regime is, reducing its legitimacy and increasing whatever kind of pressure of the government in order to reduce and to refrain from expanding its authoritarian actions or its authoritarian persona. Thank you so much. And that brings me to the end of my presentation. Thank you.
Impressive presentation about the regime violation of the right to property in West Bank, one area of Palestine. As it is seen as one of the historian place, one of the symbol of return and restore the Palestinian sovereignty, I think this will raise active discussion from the participant toward the issues regarding the close relationship between Indonesia people and the Palestine, and after being hit hard by Israeli occupation and overthrow authoritarian regime, Palestine now has made impressive effort to recovery. I think this will be very interesting for all the participants. But please hold on for all participants. The question will be discussed on the Q&A session. Now we go to the next speaker. We have Professor Dr. I Gusti Ayu Ketut Rahmi, SHM. As a brief introduction, she is the Dean Faculty of Law Universitas 11 Maret. She completed her Bachelor on Universitas 11 Maret and Master and Doctoral Program in Gajah Mada University, Indonesia. She also conducts sandwich program in National University of Singapore. Professor Ayu have various research and publication in national and international. She is also author of many national and international journal, and now known as Dean Faculty of Law Universitas 11 Maret. Prof. Ayu will have talks on the environment issues associated with green constitution and ecological justice. Ladies and gentlemen, Prof. Dr. I Gusti Ayu Ketut Rahmi, SHMM, time is yours.
Okay, thank you very much. Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh. Good afternoon, ladies and gentlemen, and all participants. Thank you for this invitation and these opportunities. Congratulate for Faculty of Law, Universitas Jenderal. Good afternoon, ladies and gentlemen. Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh. Thank you very much for this invitation and this opportunity. Congratulate for Faculty of Law, Universitas Jenderal Sudirman, for the Dean, my colleague, Professor Adi Maman, and all Vice Dean, all committee, all presenters, and all participants in the second ICOLGAS today. Talk about green constitution in promoting community welfare through social forestry and ecological justice. We talk about justice. Next slide, please. In Indonesia, basic problems, if we see, and our research, justice is main problems now. We know, if we talk about justice, we know individualism justice by Bentham, John Locke, and then there is collectivism by Plato, Dubois, and there are synthesis between individualism and collectivism, justice by Hegel, Fichte, and Radbruch. Next. Talk about Indonesia case, especially in forestry, natural resources, especially in forestry, inequality and unfair land allocation. If we see data now, condition existing, there are more than 90% land allocation in forest for big corporate, and another hand, only 3% for small corporate, especially for people. Next. Indonesia have Pancasila, the ideology Brunom, and Pancasila is a philosophy Grondslag in Indonesia. If Pancasila, which synthesize individualism and collectivism is used as the basis for the legal system in Indonesia, especially for forest resources management in Indonesia. So justice and prosperous society will be realized. Next. We can see Pancasila in Indonesia as a legal system. From every steps, Pancasila must be implemented, and we agree that Pancasila can make good norm and good process. In legal practices, Pancasila must implemented, and then in dogmatic of law and theory of law too, philosophy of law, Pancasila is implemented, and the high step as a meta principle, Pancasila as a ideology and legal system, the ideal of Pancasila. This is ideal meta principle Pancasila. But we see how about the existing condition. Next. What's the meaning national ideology or Pancasila as a national ideology? We can divide it three meaning: Pancasila as an ideology, national ideology, and as a philosophy groundslah. It means the first mean Pancasila as a positive legal basis, as a legal institution and processes. It means behavior of government, bureaucracy, and citizens must implement it. And the second, Pancasila as a philosophy groundslah. It means Pancasila as a positive legal testing tools and legal institution and processes too. So Pancasila as a behavior of government, bureaucracy, and citizens. And the last but not least, the meanings of Pancasila as a philosophy groundslah, Pancasila as a ramification of Pancasila values into various legal principles and rules that are ranged its meaning in a system. Yeah. Next. This is sila-sila from Pancasila. The first sila, ketuhanan, Tuhanan yang Maha Esa. The second, kemanusiaan yang adil dan beradab. The third, persatuan, nilai-nilai values persatuan Indonesia. And then the fourth, kerakyatan, values of kerakyatan yang dipimpin oleh hikmah kebijaksanaan dalam permusyawaratan perwakilan. And the last, values keadilan sosial bagi seluruh rakyat Indonesia. This is meta principle Pancasila that must implemented all of citizens, governments, bestur, and corporate. Three pillars. Next. So Pancasila must embodying Pancasila in all of norms, especially in environmental and spatial for forest resources management legal system. If we talk about forest resources, there are three pillars: state, civil society, and corporate. And three pillars must or need participation and legal instrument to good norm and good process in forest resources management. So if we see no participation and no good legal instrument, so we can see there are good forest resources management, both in norm and process. Next. Yeah. Talk about green constitution, we talk about tafsir kemakmuran rakyat. Tafsir kemakmuran rakyat and green constitution we can see in 1945 constitution, especially article 28H and article 33 verse 3 and 4 of the 1945 constitution. Green constitution we can see too in Forest Management Act in Article 3, Act number 499, and the 1945 Constitution, Article 28 and 33. Green Constitution gives us the understanding that all the components in the environment affect each other for life and the lives of all the components that are on the environment itself. Each component of the environment has its own value, which must be observed and respected in their interaction, the rights of environmental, and contains sustainable environmental development in Indonesia constitutionally. And Constitutional Court Tafsir or Tafsir Mahkamah Konstitusi, we can see equitable distribution of natural resources, especially forests, benefit for all people. People's participation in determining the benefits of natural resources, especially forestry. Next. Next. Yeah. If we last. Please, yeah, People's Prosperity Indicator, Constitutional Court decision. Sorry, before this slide, yeah, realization of ecological justice. Next. Yes. The realization of ecological justice we see from Brian Baxter that have ecological justice theory, and we elaborate in realization this in Indonesia, especially in forest, social forestry or natural resources, especially forest and social forestry. The realization of ecological in theory by increasing the capacity to develop community capacity and empowerment, participatory, equitable, and environmentally friendly manner, so as to create social and economic resilience, as well as resilience against the effects of external change, ensure justice and sustainable distribution of benefit. Brian Baxter talked about justice, not only humans, but also non-humans. If we see justice theory in 1819 era or century, justice is talk about justice for humans, especially for people. Yeah? For people. Don't think about fauna, flora, yeah? But ecological justice and environmental justice. Talk about justice not only human, people, flora, fauna, but also justice for non-human like water, air, and so on. So if we talk about forest management, green constitution, justice not only human but non-humans. Next. Yeah, ganti distribution. Yeah, people's prosperity indicator. If we see from Constitutional Court decision, Constitutional Court Republic of Indonesia decision, yeah, we can see benefit of natural resources for the people. Yeah. The first meanings, yeah. The second, level of equality of natural resources benefit for the people. The second, the level of people's participation in determining the benefit of natural resources. And the last, respect for the rights. Respect for the rights of the people from generation to generation in utilizing natural resources. This is Constitutional Court Republic of Indonesia decision, the meanings of people's prosperity indicator. What kind of indicator called people's prosperity? Next. Yeah, guarantee distribution of justice. Yeah, as a implemented people's prosperity indicator, we can see from three bases: philosophical basis, sociological basis, and the last, constitutional basis. In philosophical basis, there are talk about social justice, the distribution of benefit. We can see sila Pancasila, or 5 principles. Yeah, Pancasila, especially the second sila and the fifth. Yeah, sila kedua dan sila kelima. Sila kedua, kemanusiaan yang adil dan beradab, dan keadilan sosial bagi seluruh rakyat Indonesia. Sociological basis, so far there has been an imbalance in distribution of benefit. Yeah, we can see data, empirical data, 96% corporation, big corporation, and only 3% public or people, 3%. So social forestry actually is a way or solution to overcome the imbalance between big and small. Yeah. Social forestry as a way or solution to overcome the imbalance of distribution of forest benefits. We can see in Permen LHK 2016 on social forestry. And the last, constitutional basis, Article 33 of the 1945 Constitution, and Article 2 and 3 Act about forest management. And the last conclusion, next, please, next slide. Yeah, the last, for the greatest justice, for the greatest justice and sustainable prosperity of the people, by five solution, 5 steps. Ensure the existence of forests with sufficient area and proportional distribution. The second, optimizing various forest functions, including conservation, protection, and production function to achieve balanced and sustainable environmental, social, cultural, and economic benefit. And the third, increasing the carrying capacity of watershed And the fourth, increasing the capacity to develop community capacity and empowerment in participatory, and then equitable and environmentally friendly, so to create social and economic resilience as well as resistant to the effect of external changes, and the last, ensure equitable and sustainable distribution of benefit. I think that's all our presentation. Thank you very much. Assalamualaikum warahmatullahi wabarakatuh. Terima kasih.
Prof. Ayu, very impressive presentation and interesting issues. As we all know that the implementation of green constitutional concept in Indonesia is in the context of restoring human rights of the people toward environmental sustainability and social justice is very interesting and debatable. I think the discussion will be very interesting. Okay, go to the next speaker. Join with me today here is Professor Trilisiani Prihatina, MA, PhD. Good afternoon, Professor.
Good afternoon, Mbak Ulil.
Prof. Tri is well-known professor in Faculty of Law Jenderal Sudirman University in Indonesia. She finished her bachelor in Gajah Mada University and master and doctoral program in Murdoch University, Australia. She is also the chairman of Private and Business Law in doctoral program Faculty of Law Jenderal Sudirman University. Without further ado, please welcome Prof. Trilisiani Prihatina. The time is yours.
Thank you very much, Mbak Ulil. Assalamualaikum warahmatullahi wabarakatuh. I think today and this moment is amazing event for us, for all of us, and especially for me because this moment in Faculty of Law, we have International Conference of Law, and it's a pleasure for me to share a bit about my knowledge about sustainability and responsibility. Actually, today I want to talk only about a few things, especially I want to share that we should understand exactly about what is the sustainability itself. And several points that I want to discuss and to share with all of you about the sustainability and development, sustainable development, and who's responsible, and also the approach of sustainability itself. But before I start, I want to thank a lot for amazing organizing committee that for a few days and a few weeks and it might be a few months, they spend a lot of time to organize this meeting. And also thanks for the leader of university and faculty who give us this opportunity to express and to share the knowledge of law. And I will start with this actually a few comments here. So when I asked a group of people from law, then I asked them, what is the most important things as a knowledge? They will answer law. And then when I asked a group of people from economy faculty, I asked them, so what is the most important things in the life? And they will answer economy. And then when I asked the a group of people from the health department, then I asked them, what is the most important things in this life? They will answer health. And then because of different point of view, then we have to rethinking actually what is the most important in this life. Yeah, and based on that meaning, I will argue later actually. So what's the notion of sustainability itself? What's the meaning of sustainability itself? Then there is a few answers some people, some experts argue that something is sustained when there is growth. And other experts argue that sustainability should be meant by continuity. Yeah. And some other experts argue that something is sustained when there is balancing life between material and spiritual aspect. And then we have to think over about this. And what about the other thing? Actually, it's not easy, because when we have the financial problem, some people say financial is the most important. And what about the communication problem? For example, there is in terms of the knowledge of communication, then between two partners, communication is very important. And then we have to think again. Actually, the meaning of sustainability itself, it's 1,000 of meaning. It just depends on the situation that we have to face. For example, at the moment, the era of COVID, then you have to ask among the poor, so what is the important things? They will answer, I can give food for my family. When you ask the wealth, so what is the important things? They will answer, health. For the poor, health might be, and I'm sure it's important, but if they have to keep themselves with no money, with no food, due to health aspect, then they will answer that it's not sense. It's not sense at all. It means they have to go out, get the money, and give food for the family. So if you ask a family with for example, with the IQ under the normal, and then you ask them, hey, for your kids, which one is more important for your kids? They will answer, I can help my kids to be normal kids. But it's impossible, because some parents, unfortunately, they have a kids with the intelligence under the normal. So it means for them, okay, if my kids can feed themselves, can drink themselves, it's enough. So it means that sustain could be many meaning. And so how is the step of sustainability itself? Actually, we can see that when we start talking about sustainability, we have to see the problem, the daily problem in our life. Either it's personal or either it's a group. So when a personal, it's only, for example, it's only a few people in this village, it's poor, cannot eat. But if most people, many people, or a lot of people cannot feed themselves, they cannot have proper food, then that is the problem. So we can see the problem and the daily life. For example, if there is a lot of people have relation with no marriage, if only a few, that's problem, individual. But if a half or a 1/3 of community, all of them, 1/3 and or a half have a relation without marriage, then that was a problem. Although one relation with no marriage is a problem, but it's individual. So how was the individual solve the problem? We can see from the second part of this diagram that how the recovery That's problem. For example, now we have a lot of people lost their job and less earning money because of COVID. Then how was the moral discourse here? Put a lot of significant effort. For example, either it's individual or it's institutional moral craft. It means one individual, they decide, okay, I will rob the people. So I will thief the people. And in the institutional level, we can see how was the local government, how was the local people, how was the state government, how was the central government solve this problem. For example, in case of Indonesia, we already have the law of karantina, the law number 9, the law number 6, 2018. But it is not implemented yet, especially in terms of the state obligation to feed the poor on the people who lost, who cannot afford to feed themselves. And then the government have the new regulation that release the central government for providing the food for the poor. So in the sense then, the second step of the sustainability is take a place. And in this recovering this problem, it's depend on how the individual, how the institutional believe their moral discourse. But at the moment, I'm a bit pity because the number of criminal increase. It's not because of they want to be rich among the poor, because they have no food, they have no job, and they have a family at home that they have to feed. So it means that some people, a lot of people among the poor, they involved in the criminal act because of they have no other choice. And but at the moment also there is but among the have, it's a question: why do they still doing something that unlawful? And the next step, the third step, is recovering in everyday practice. That is, I already mentioned that in recovering the problem in everyday life, then it's entirely depend on the people. It's not much people, they will say, okay, I will, I better die rather than stealing something. But some other people prevent, okay, well, I will steal something for the family. Yeah, that's it's not easy option, but I will show later how is the state's position in this problem. Yeah, and we can see around our people, and when we go out from our house, so how many neighbors that cannot recover because of COVID, for example. And if, okay, all of them are their welfare family, then we have to go a bit further. So how many people they cannot survive because of COVID? Okay, and I will explain a bit about the development. Sustainable development itself, I already mentioned. Sustainable development. Can please the slide, please? I can explain a bit about the meaning of development. So, actually, if we ask, do we develop already? Because of we already bachelor, or because we already take a master degree, or because we already take a doctoral degree, or there is other meaning of development. In the sense, then, I found a couple of meaning of development. First, something the people, okay, I will not develop because my salary already 20 million rupiahs, for example. And then we found that some people with the salary of 2 millions, do they not develop? So then there is one meaning of development is growth. And growth itself means that it's usually used by to evaluate or to indicate the macroeconomic success. Other things at the meaning of development where there is a fulfillment of human rights. It means that okay, there are freedom to speech and there are freedom to move, and there are freedom to choose the food, for example. So later on, I will find whether we are the rationale for choosing the food, or the rationale for having release from poverty. And the meaning of development is the right of basic need. In this sense, I will give an example. For example, the right of food. Some people say, okay, I'm happy enough if today I can eat sufficient food. What is the meaning of sufficient? Some people happy enough with nasi rames. But some other people, I'm not happy with nasi rames. I'm happy if I eat KFC, for example. So if I'm happy if I can have a cup of coffee in Starbucks, for example. Although in Starbucks it's not cheap though. And that's and we have to look at ourselves. And we have to look at our, the policy. And another things that I told already about I will combine the meaning of sustainable development. In terms of how is the involvement to the country where there is a lot of poverty and there is the strict budget from the government, then I will borrow the concept from the World Commission of Environment and Development. Development, it's mentioned like this: sustainable development, development which meet the need of the present without compromising the ability of the future generation to meet their own need. What does it mean? It means that whatever we consume, whatever the budget that we need today, it cannot danger the future of our children. So in application this, the concept from the World Commission, the government of Australia, for example, in 2003, because they are a developed country, but they have the principle like this: state should avoid future debt, and business needs to minimize the sovereignty risk. It means if we have more debt, it might be solve this problem today, but later on, our future generation will take all those responsibilities. That's why, in this sense, then, the question is, so how far the state government, the government could borrow the money from the outset that not burden our future generation? That is a bit question that it might be could be a couple of papers if we can write down this topic. And another that I borrowed the concept from Atkinson, sustainable development is increase the well-being for the better off in the society, which come at the expense of those who were worse off. It could be the level at the family level, community level, local government, or in the community and another community, and between the country. It means that we cannot have a better life, but it does the expense for the worse off. In the community, we know that we have the bank plecit. The blank plecit, in the short term, it solves the problem. But in the long term, it will bond the people who lend the money for a long term. And it's not easy then, because it also this problem come up with at the countries, between the countries level. Okay, and so how to solve this economic problem? And then Bu Ayu mentioned about the ecological problem and about the community problem. So we have actually should balance those three things. So balancing those three things, it link it between three aspects. That was the sustainable development. It means that from the community, for example, so what is the most important for the community? Religion. So for them, for example, if, okay, life, whether they are poor or they are wealth, so they think that religion is important. So okay, let's them life and let's the religion lead to the better life. What about the ecological? So it means the sustainable development should link it. So in the middle of these three cycles, that was the sustainable development. It might be some other expert have that different theories, that's fine. But that's why at this moment, the omnibus law, the draft of omnibus law, a lot of critics from other, from the society, from students and from the NGO, from the workers, because it seems, but we have to look at again, it seems that from the omnibus law, they put aside the ecological aspect. So they put aside ecological aspect. So from the chance of working, and then for job seekers, so we have to look at it again, whether the draft of omnibus law is good enough for us or not, and with the rationale behind the decision of us. And so is there any instrument that lead to the sustainable development? A couple of instruments actually, either from international instrument and from local instrument. But those instruments mostly focus on the notion that who should be responsible for this sustainable development, including the access to the food, access to health, access to house. Actually, from the law number 7, 1996, and from the international level, from the ECOSOC in 1966, actually the state should be responsible. So, so how is the state responsible? Actually, there is a couple of approaches that could be used to implement the sustainable and to understand what the sustainable step. And basically, all the level of apparatus should understand this. There is an approach like the maximal and minimal approach. It means that, okay, I just give you for, what's that, 600,000 rupiahs a month for a whole family. And to choose which one is the family, it's entirely depend on the lead of the neighborhood. So, so that's the minimalist approach. So about the maximalist approach. The maximalist approach means that every single people in Indonesia, for example, then they have to have adequate food. Adequate, what adequate means? Some people eat only once a day, and the other eat twice a day. So which one is the more important? So which one is the right one? And that is we have to clarify that if I eat once a day, it might be enough because I'm fat, I want to be slim. But for the poor, you can ask them, how many times you want to eat and what kind of food you want to eat. So is it, for this moment, for example, is it make sense that with the 2,000 rupiahs, you have to eat, you have to buy something? What do we get from 2,000 rupiahs? Because at the moment, I think 5,000 rupiahs, you can have one a bowl of rice and with vegetables and one, it might be a half of eggs. Yeah, it's then that was the notion of maximalist approach and minimalist approach. And you can see how was the government, for example, to implement this approach, whether they give maximalist approach or minimalist approach. And at the moment, for example, if you recognize from the television or you recognize the neighbors who are really don't have any, really poor, and then you have to, how is their life? If, and how will they run the family? And another thing that, another approach to implement the sustainable development itself is that whether we have to recognize how is the type, the kind of top-down policy and bottom-up policy. It means that top-down approach means that the approach that taken by the government, for example, either local or central government, in terms of solve the problem that we face at a certain time. And then in the long term, whether the policy from top-down approach result in better off or in worse of the future of our generation. And it might be, for example, at the moment, we borrow the money from outside, a lot of money. Then, for this couple of months, maybe this couple of months, then we can have solve the problem. But when the time due to return the money, that is the problem. So I already mentioned earlier when that we not expected to give burden to our future generation. Okay, that's the approach. There is actually another approach that we call it practical and political approach. Practical means that the fulfillment of the practical needs, like food, like health, like what was this? Food, health, and the political approach means that it means that we have to link with that the impact in the long term. I think I have to conclude with this with my time by focusing that the prime responsibility of the sustainability itself rests on the state, although that in the international level will involve also, but at the pandemic era, for example, at this moment, the other country also have their own problem. So understanding the sustainable development, it's like a dilemma between, so what should we do? Actually, this is the this option of person, the option of institution, and the option of government, how the morale behind their policy or behind their decision. And another that I want to highlight is that government policy determines the living standard of the present and the future generation. So whatever the government takes the policy at the moment, it will result to the impact to our future generation. And other thing that Mr. Thomas already mentioned that actually in the society and democratic era, actually society should shape the state policy. So society should participate in the policy. So, and then we can have a look at the moment, how was the situation. I think I want to share with our colleagues around Indonesia, and also how was the dilemma of sustainability, but the most important is how was the moral craft behind this policy or the decision could shape the better life. I think I return the time to Maulil as a moderator. Thank you.
Thank you very much. Thank you very much, Prof. Trilisiani. Was interesting talk about the sustainability and its responsibility and how law playing role in the sector. Okay, ladies and gentlemen, now we go to the Q&A. We already have some questions. I conclude there is some question for three of the speakers. First, for Mr. Osaid Awauda, there is three questions. First, is Palestinian now under authoritarian regime of Israel or Palestinian Authority? How Palestinian deal with authoritarian regime, and what is the significance of the impact of Dahlan case for the right to property in West Bank, Palestine? The second question is, are there any legal provisions that can be used for the Palestinian people in order to carry out election legally? And what legal effort have been made by the people who want to change in order to form a strong government that will prosper the people? Also, what are the obstacles faced in changing the regime, and has there ever been effort in changing the regime since 2007? Also, there is a question from our official YouTube channel. Mr. Osaid, can you give us more explanation about Rawabi case, the significance of the case and the recent condition there? I think our participant very interesting with Palestinian condition. And for Prof. Ayu, there is two questions. There are two questions. The first, how the implementation regarding ecological justice in Indonesia, and second, how the synergic collaboration of Indonesian institutions and the readiness in implementing the green constitutional and the biggest potential obstacle on it. For Prof. Trilisiani, the question from Mr. Anang to Prof. Tri. Dear Prof. Trilisiani, your presentation is very interesting. Sustainability and its responsibility have good point of view in recovering in moral discourse. Would you please to explain more about evidence of the case? And the second question for our participant, good afternoon, Prof. Tri. Allow me to respond your beautiful insight regarding sustainability. As commonly understood, there is also sustainable development goal in global scale. To that extent, what should be added in the step of sustainability as you have presented to ensure sustainability at personal, institutional, and global scale applied in a aligned way? I think these are for the question. Maybe for the first question, we go to Prof. Osaid Awauda to give the answer, please. Prof. Osaid, the time is yours.
Thank you, Ayulil. Actually, lots of questions were asked by the participants, and that is heartwarming. It seems that the subject was interesting for many of them, and that's great. There are a lot It's a bit difficult to remember all of the questions and give answers to all of them. So I'll just start by what I can remember. First question was about the regime in the West Bank. Is it an authoritarian regime or not? Yes, it is an authoritarian regime. Since 2007, we have not had an elected government, an elected parliament, or an elected president. The term of the president ended in 2009, and the term of the parliament ended in 2011, and the term of the government was brought to a termination when the Palestinian president resigned the elected government of Hamas. So yes, since the government does not represent the people, it is not a democratic government, and it is not a democratic regime. The opposite of a democratic regime is an authoritarian one. So the Palestinian government is, or the regime in the West, in Palestine, the West Bank, is an authoritarian regime. With regards to the regime in Gaza Strip, the term of the government, the elected government of Hamas, ended in 2011. And until now, the government is running as an interim government, not an elected one, until a new elections take place. The question that follows is when elections will take place in Palestine. This needs immense support from the international actors, specifically the United Nations, the EU, the European Union, Russia, and the United States. And as you can see, it's a bit hard to believe that those four actors would support new elections in Palestine. The Israelis want to continue their occupation at least, or with the least costs, and they want to continue their normalization of relationships with other Arab regimes. So it's for their benefit to keep the Palestinian government an authoritarian one, so that they continue to claim that they are the only democracy in the Middle East, and try to convince other people or other Arab regimes to take part with them and support them. Now, with regards to the third question, which is about legal provisions that can be used for Palestinian people to carry out elections. Yes, there are lots of legal provisions in the basic law and in the law of elections that would make it binding and obligatory for the government to hold elections. But as you know, in order to perform or to act upon a certain legal rule or to apply what is mentioned in a particular article, you need a political will and a governmental will, which means that the government wills to apply the law, or the political parties will to apply the law. And this kind of will, it seems that it is absent. There is no clear answer about when political parties in Palestine will agree on holding new elections. There has been some talks recently about whether the elections should take place sooner or later, but in the near future, it's hard to see elections taking place. The fourth question, what legal efforts have been made by the people who want to change in order to form a strong government? Many people tried to hold protests and mobilize other parties. They tried to submit applications and cases to the Constitutional Court to remove their legitimacy from the current authoritarian regime. But the Constitutional Court, as an institution that has been single-handedly built and established by the Palestinian president, it is not independent. It gives what the president wants. And until now, almost all of its cases in sensitive matters has resulted in decisions that are in favor of the president and his clique in Fatah party. Clique means they're people who support the president. Fifth question, what are the obstacles faced in changing the regime? The main obstacle is a security obstacle. Whenever people want to hold protests or want to act against the government, they are arrested, tortured, and in some cases killed by the security apparatus in the West Bank. I know that this might be surprising for many people who are not Palestinians, people who are concerned about Palestine, like many of my fellow Indonesians. Unfortunately, this is the case, and this is the reality, that the Palestinian government in the West Bank is terminating any kind of resistance or any attempt to stand against it, or even against the Israeli occupation. The sixth question, has there ever been efforts in changing the regime since 2007? Yes. One of them was, I believe, in 2011, in which people tried to hold elections for at least in the segment of, related to only the parliamentary elections. But until now, none of these efforts have been fruitful. All of them were just gone in vain. I forgot, sorry, Olin, what was the question asked on the YouTube channel? Can you please remind me of it?
The significance of the case and the recent condition there. The Rawabi case.
Can you please repeat?
The question from our YouTube channel is, Mr. Osaid, can you give more explanation about Rawabi case and the significance of the case and the recent condition there?
Yeah. Now, again, Rawabi case was a case in which a decree by law was challenged on constitutional grounds. That decree by law expropriated a huge area of private land and gave it to an investment company. That investment company was called Rawabi Investments. And in that incident, Rawabi Investments built the first man-made city in the West Bank on the land expropriated by the Palestinian president. People challenged the decision taken by the president and the Constitutional Court. The court said that it lacks jurisdiction according to the basic law over such a decree, while the law of the court itself while the court of the law itself allowed for over reviewing such decrees by law. The significance of the case shows that constitutional courts in authoritarian regimes such as Palestine do not practice the right function of holding justice or protecting the constitution. They provide 5 different functions. One of them mainly is providing credible commitments in the economic sphere, and that was the case for Palestine. So it is a lesson to be learned about constitutional courts, and not think that constitutional courts do always protect the people and uphold the constitution. In many circumstances and many instances, they do the opposite. They provide help and support for the authoritarian regime.
Really open our mind and giving us clear and accountable about the recent condition of the development on law and social justice there in Palestine. Thank you. Now go to.
Thank you so much.
Thank you very much. Now we will give time for you to give the closing statement after all the question being answered from all the speakers. Okay, now go to the next speaker, Prof. Ayu, to please answer the question from the participants.
Okay. Thank you, Mbak Uli. Yeah, 2 questions for me. Good question. One question, how implementation ecological justice in Indonesia? Yeah, we know ecological justice is justice not only for humans, but justice also for non-humans. Yeah, how implementation? Yeah, the first from legal. If we talk about governments, yeah, at the national level, not only at the national level, but also in local government, about legal drafting. Yeah? About legal drafting, I think must embodying Pancasila principle that have 5 principle or 5 sila, have 5 sila Pancasila, and then we talk about one requirements, how to get good what we call legal good norm and good process to get good what we call legal product at national level and local government. One requirement is participation, increasing the capacity to develop community capacity and empowerment participatory. So I think one requirement that we must implement it. And then we have Act 32, 2009 about what we call environmental management and protection, that if we make legal product must based on environmental perspective or ecological justice perspective. And the second question is about how synergy some institution, I think three parties, government, and then people and corporate, yeah. State, society, and corporate. Three pillars that make forest resources management as a part of environment perspective, yeah. To synergy one each other and needed participation and legal instrument. I think that's all, Mbak Uli. Thank you very much. Hello.
About the development. Thank you very much, Prof. Ayu, for your construction knowledge about development of the environmental and green constitutional law in Indonesia. Very fruitful for us today. And now go to next speak, Prof. Trilisiani Prihatin SFPCSC to answer the question.
Thanks the question for Mas Nanang, yeah. I'm not mistaken. I have to question from of them guys, and its question is about what's this, about the moral discourse, and the other one is what should be added in the step of sustainability. Actually, the answer is not what should we add. What should we add as an answer, but I give the illustration like this. If the driver of 3 cycles, they already work for 10 hours a day or more than that, and they still cannot have a proper life. Let's say for food, not enough, for health, it's not enough. So so where should we start? Actually, for me, we have to start with from the daily problem. So the daily problem then, actually the scale is to narrow. Yeah, because we have to start in the democratic era, we have to start from the individual freedom. It means that the state should have their function, have 3 functions. Actually, this is the theory. But the theory should be implemented to protect or to promote or to fulfill the needs for the people. And then if for the poor, they cannot have enough food, for example, then why do they cannot enough food? I answer these 2 questions in one term, that from the personal, we can have a look from the personal, from the community, from the institution, and from the state or the government policy. So the personal, that might be how the moral discourse shape their decision. And they have different decision. For example, I give you one. If, okay, I have no money, then I will steal some other, someone else. Then they become thief because they're stealing someone else's property, for example. And the other people respond differently. They have more creative, or let's say it's not creative, but okay, I will sell the mask, for example. Because at the pandemic era, you have now a lot of people, they run the business with the creative way. And I know someone at the beginning of the pandemic, they're selling, what's that? The kentongan. The kentongan, tung tung tung, from the bamboos. And because no one, not all the people can buy, what's that, the camera? CCTV. So they have kentongan. So the kentongan can sell. A lot of people, they are interested. And it also bond the community. What about the family? The family level should involve to solve the problem, for example, the poverty, for example, and the community itself. But according to the, what's that, the institution, the law, then the state still the prime responsible for to implement or to implement the sustainable development. It means, in this sense, in this problem, then to solve the poverty. So what about the state? Then we have to, I just dream sometimes that if you are a dean, for example, then you have to concern with the people that you that in your hand. So if you are elected as the lead of, for example, the Bupati, for example, then you have to responsible that no one will, everybody should have enough food at my area, for example, like this. And if you are a president, for example, the president should think that no one will live or no one will die because of they are poor, they cannot eat, they cannot study. So then in the different scale should have different responsibility. And the second question, it's interesting, ask me, so what should we do? I think we have to have the indicator that could be measured, in every step of sustainable development. So it means that, okay, well, if someone can have a job, then we have to know that whether he's with this job, he can run the family or not. So what about the global scale? The other question asked me, what the sustainable at the global scale? At the level of government between one another, then we have to know what is the, actually I already mentioned in my paper, I told that there is 3 indicators of sustainable development. There is community, social, economy, and environment. Among these 3, in reality, economy still lead the 3 aspects. And now we have to make a connection between how was the economy aspect, ecology aspect, and also the community relation between Indonesia and United States, for example, or with China, for example. And some people that criticize that a lot of workers from China at the moment works in the remote Sulawesi. And then I argue, that was the responsible of China's government or Chinese, what's that? Chinese company, for example. Because there is the duty of Chinese government responsible for their people, and the duties for Indonesian government responsible for Indonesian people. Of course, because they are very dense population, then they try to sense the people around the world to have a better life. No doubt about that. That's why the Indonesia should think the same things. So there should be very tough negotiation between Indonesia and some other countries. And it is not easy. That's why we choose you as a leader of us. That's why it's not easy to become a leader. Because there is a lot of more responsible on their shoulder. I think that I mentioned that one thing is that the indicator should be measured in all the level of the what's that? Of the either personal, institution, community, government, as well as the local and central government. I think that's all, but I want to sharing the idea of sustainable development.
Okay. Thank you very much, Prof. Trilisiani and all the speakers. We do understand that the Q&A times will not enough to answer all the questions. I see the question in chat room keep flowing, but apologies to not be able to read more questions because we still have other session after this. I think all the speakers can contact by email or other platform to discuss further about the question. Please be willing, Mr. and Mrs. Speaker. Now time for each speaker to give closing statement for about 1 or 2 minutes about the presentation and the conference. We can start from Mr. Osaid, please, to give the closing statement. Mr. Osaid?
Yes, I can hear you. I was unintentionally muting the video. Yes, to give a closing statement, the presentation that I've given was about how a constitutional court in an authoritarian regime legitimized the regime's attempt to expropriate private land and violate the right to property given to the people in the basic law. The importance of such a conclusion is related to the fact that constitutional courts are not always for justice and for fairness, but in many regimes, especially in authoritarian regimes, constitutional courts are used as a tool to further control the society and achieve all of the ill purposes and unjustified goals of the political party, especially the dominant party, such as that of Fatah party. Palestine is still going through lots of struggles, and once we have an elected government, a new constitutional court can be established. Then that constitutional court can provide further justice and protect the social rights of the Palestinian people, especially the right to property.
And now to Prof. Ayu to give the closing statement.
Yeah, thank you, Mbak Uli. Yeah, my closing statements that the 1945 Constitution of the Republic of Indonesia mandates the governments, entrepreneur, and all elements of society shall exercise protection and environmental management in the implementation of sustainable and environmentally sound development, and through social forestry, one of the programs our governments, that also refers community-based forest management is defined as a sustainable forest management system in the state or one state forest area carried out by the local or indigenous communities to improve their welfare, environmental outcomes, and social culture. That's all, Mbak Uli. Thank you very much.
Trilisiani to give the closing statement.
Okay. Okay. Yeah. Actually, I just want to say that in terms of sustainable and its responsibility, actually it's not only in terms of what we choose in the different situation, and everybody, every institution, every government have a difficult situation, and this option actually not only show how is the option that we take, but also what the moral message behind that decision. And that one thing I want to focus at the, please don't take our future generation in the difficult race in the future.
Thank you very much. Thank you for all the insightful knowledge from all the distinguished speakers. It is our privilege to have you all here. Hopefully we could build more meaningful and fruitful collaboration further after this conference. Thank you again, Prof. Osaid from Palestine, Prof. Ayu from UNS, and Prof. Trilisiani from UNSUD. Ladies and gentlemen, now the plenary session 2 is safe to conclude. I apologize if there is any mistake in inconvenience. I close the session. Wassalamualaikum warahmatullahi wabarakatuh. Back to the master of the ceremony. Thank you.
Thank you for Mrs. Ulil Afa for leading this session.
And ladies and gentlemen, now we would like to give virtual certificates for the speakers. First, Assistant Professor Osaid Awada LLB LLM PhD from Hebron University, Palestine. This is the certificate. Thank you very much. And second, Professor Dr. Igusti Ayu Tutrahmi Handayani SHMM from Universitas 11 Maret. Thank you very much.
And now for the third speaker, Professor Trilisiani Prihatina, SHMA PhD from Universitas Jenderal Sudirman will get special placard that will be delivered by Vice Dean of General Affairs and Finance for Dr. Nur Indriati, SHM Hum. Please come forward.
Thank you very much. And now, ladies and gentlemen, by the end of the plenary session 2, finally we get to the end of this opening ceremony. I am Surwayu Handayani.
And I'm Muhammad Irfan Ramadhani.
Would like to say thank you very much for attending this event.
The next agenda will be continued by parallel session 1.
But before that, please enjoy a break time for 22 minutes with a special virtual tour of Purwokerto City.
Wassalamualaikum warahmatullahi wabarakatuh.
Good afternoon.
Jenderal Sudirman University is one of 122 public universities that have been established in 1963 located in Purwokerto, Central Java, Indonesia. In accordance with the mandate stated in the preamble of the 1945 Constitution and the Banyumas community's insistence on the need for higher education, the formal and informal leaders of Banyumas initiated the establishment of colleges in the Banyumas region. As a follow-up to this idea, based on Notary Date number 32 dated September 20, 1961, a foundation of Jenderal Sudirman University was formed. Then by the Presidential Decree of Republik Indonesia number 195 dated September 23, 1963, Jenderal Sudirman University was officially established and was inaugurated by the Minister of PGIP, Professor Dr. Tojeb Hadiwijaya, at the official residence of the Banyumas resident. The establishment of Faculty of Law Jenderal Sudirman University was preceded by the formation of committee based on the decree of the Jenderal Sudirman University Council through a decree number 022/PT30Y/E 1979 formed a committee to explore the possibility of the Faculty of Law establishment. In its progress, the committee made a complete plan to establish the Faculty of Law. Through a wire letter dated May 13, 1981 from the Director of Academic Facilities Development on behalf of the Director General of Higher Education of the PNK Department, the Faculty of Law Jenderal Sudirman University was began accepting students in the 1981-1982 academic year. Furthermore, based on the Presidential Decree number 50, 1982, the Faculty of Law officially became one of the faculties within Jenderal Sudirman University. Currently, in 2018, Faculty of Law is led by Professor Dr. Ademaman Suherman, SHMSG as the Dean, Dr. Setia Wahyudi, SHMH as the first Vice Dean, Dr. Nur Indriati, SHMHum as the second Vice Dean, and Dr. Kartono, SHMH as the third Vice Dean of Faculty of Law, Jenderal Sudirman University.
Faculty of Law Jenderal Sudirman University was established in 1981. Our university is located in the southeast of Central Java, which is surrounded by natural beauty. Faculty of Law is one of the 12 faculties in Jenderal Sudirman University. In accordance to the faculty vision, all the faculty members committed to bring the faculty as a center of excellence in education and development of legal science that based on the local wisdom and global competitiveness. In terms of accomplishing the faculty's vision, the following missions are briefly described as follows. Firstly, conducting a legal education corresponds to academic standard with good moral integrity to produce graduates who have high competencies, professionalism, and global competitiveness. Secondly, conducting research to develop the legal knowledge that related to national, regional, and global development necessity which dedicated to the human welfare. And thirdly, disseminating the result of the legal science research through scientific publication, legal review, and community service which based on the local wisdom. In the present, Law Faculty of Jenderal Sudirman University already established postgraduate degree in 2002, Master Notary program in 2017, International Undergraduate Program in 2018, and doctorate degree will be open in 2019.
In order to realize the vision and missions, Faculty of Law Jenderal Sudirman University has several teaching staffs as a supporting system besides the employees, which are 67 teaching staffs which consists of 5 professors. They are Ademaman Suherman, SHMSG. Second, Professor Dr. Trilisyani Prihatina, SHMA PhD. Third, Professor Dr. Agus Raharjo, SHMHU. Fourth, Professor Dr. Hefri Nugroho, SHMH. Fifth, Professor Dr. Muhammad Fauzan, SHMHU. Also 17 doctorates and 45 masters. The teaching staffs are spread into 8 departments. Basics of Legal Science Department, Civil Law Department, Criminal Law Department, Constitutional Law Department, State Administrative Law Department, Law and Society Law Department, Procedural Law Department, International Law Department. Faculty of Law Jenderal Sudirman University manages several programs. 1. Undergraduate Program, regular class of Bachelor of Law since 1980, graded A. That translate excellent for 4 times in year of 2000 until 2015 by National Accreditation Board of Higher Education, or BAN-PT. International Class of Bachelor of Laws since 2018, which is now also undergoing accreditation submission process. 2. Graduate Program. Master of Laws awarded since 2002A, the Transit Excellent in Year 2016 by National Accreditation Board of Higher Education, or BAN-PT. 3. Doctoral Program. Under progress of establishment. In an effort to ensure the quality of legal education in line with the changes in global trends, we have made international cooperation efforts with various universities across the globe through partnership. 1. Yongsan University, South Korea, since 2016. 2. Mahasarakam University, Thailand, since 2017. 3. OP Jindal University, India, since 2017. 4. Jose Rizal University, Philippines, since 2018. 5. Limpopo University, South Africa, since 2018. Faculty of Law Jenderal Sudirman University has various facilities, which are: the facilities of Faculty of Law Jenderal Sudirman University is divided into some buildings, which are: Justisia 1 building with 12 lecture rooms, 1 court practice room, 1 law laboratory room, Master of Notary Program Office Room, Consulting and Legal Aid Bureau Room, Legal Dynamic Journal Room. Justisia 2 building, 4 lecture rooms, 8 lecture rooms per section, conference room, teen room, Master of Law Program Office Room. Justisia 3 building with Scientific Information Center Room, Video Conference Room, Librarian Secretariat Room, Hall, International Class Office Room. Justisia 4 building with 4 court practice rooms, 16 student activity unit rooms. The student activities in Law Faculty of Jenderal Sudirman University are not only focusing on academic activities that limited into lecture room, but we also fully facilitate students to be progressive through organizations like Student Executive Council, Student Legislative Council, and Student Activities Units that's divided into 2 bases, which are activities-based and interest-talent-based. Faculty of Law Jenderal Sudirman University always in and eager to strive to be a leading contributor by working hand in hand among the academic community to make the faculty better in the future. That in line with our watchword, keep moving forward and never give up.
The birth of Jenderal Sudirman University cannot be separated from the complexity of the countryside. Villages have a very strategic role in national development. Being in a rural area with an agrarian culture, making Jenderal Sudirman